affidavit
My lordship.
as per that what Neha versus Rajnish.
No, lordship. Neha versus actually, we in that case, section 24 petition will automatically go to once section 25 petition is allowed. So section 24 petition will not survive. In the event section 25 petition is granted.
Now who is arguing? You are arguing, madam.
No, my sorry, senior will argue.
Where is the senior?
He's in court number 21. He's in lakhs, my lordship.
Is he ready for today?
No, my lordship. And the matter may be adjourned for a week. We will do it, my lordship.
Okay, on the prayer made on behalf of Mr. N.N. Jha.
My lordship.
Then counsel for the
Respondent.
respondent.
Respond.
List the matter after a week. To start.
Oblige, your lordship.
In this case, comma, though the applicant appellant
Lordship.
had made a challenge to the divorce decree, comma, the petitioner in this application has apparently decided to forego the challenge made to the divorce decree,
Lordship.
provided the applicant is paid permanent
Reasonable.
alimony and maintenance.
Lordship.
That's your case.
Lordship.
List the matter after a week.
Oblige, your lordship.
May praise the Lordship. Lordship, I beg to make a mention for listing of a contempt case. Lordship, it was last posted on 31st May, but due to paucity of time, it could not be taken up by the Honorable Court.
Have you asked the registry to post it? Ask the registry first. If nothing happens, then you
Lordship,
come
I
here.
asked the registry, but registry has told to mention before the.
When did you ask who did you when did
Friday
you
I have
ask?
asked, already
Friday.
I have asked,
Okay, when do you want?
day after tomorrow. Matter pertains to bench number, court number 1.
Court number 1.
There's some urgency in that regard.
Okay, Friday. When is this?
Highly obliged.
May I please, Lordship? Lordship, I beg to mention for listing. It's a bail matter, Lordship, NDPS matter. I have filed an IA for bail. Lordship.
DPS matter, bail matter before division bench.
NDPS matter is NDPS. I have filed an IA for bail, Lordship.
I for bail.
Yes.
Acha,
IA, Yes.
You mean it's an appeal? There's an
Yes.
appeal.
yes, criminal appeal, Lordship. With appeal, I
Okay.
have filed an IA.
When do you want?
Monday, Lordship, 12th March.
May it please your lordship, I'd like to mention case number read appeal. It was fixed for the honorable division bench 1. It was fixed for today, your lordship, as per order dated 12/5/23. But since the bench is not doing, it did not come up. Since there is urgency in the matter, it pertains to a tender. Your Honor, may be pleased to fix it on 7th, that is day after tomorrow.
Okay.
Much obliged, your lordship.
Jail appeal, your lordship.
So we'll
1 to
we'll
4.
admit this appeal.
Yes. And amicus curiae to be appointed.
Yes, yeah, this
to 4.
this is an appeal against the judgment dated judgment dated 9/3/2023 passed by the Court of the Sessions Judge, Karbi Anglong Diffu in Sessions Case number 1/2022, by which the appellant has been convicted under section 302 IPC. Admit the appeal. Call for the LCR. Who do we appoint?
Among the Sagarika Bolu.
Miss
Sagarika Bolu.
is appointed as
Lordship.
is appointed as the amicus curiae in this case. This is the matter. After 4 weeks.
Obliged lordship. Your lordship
Anything
has called for a record.
Yes.
ma'am. After receipt of the LCM.
See, suppose it comes after 2 years, then
Oh, yes, yes. ma'am. Obliged. The Chaudhary can be appointed, Bornali Chaudhary.
I do not know whoever. We leave it up to you, but you see, there is a.
There's a set of lawyers, my lord.
Heard. No, right, this is an appeal against the judgment dated 6/3/2023, passed by the court of the Sessions Judge Karbi Anglong Diffu in Sessions case number 23/2021 bracket old under section 30, no, by which the appellant has been convicted under section 302 IPC. Same thing, huh? So is appointed. Huh?
She's interested.
She's interested. Is she in the list?
She, her
Yes,
name
lord.
is there. Legally counsel. Amicus.
Okay, this is an appeal against the judgment dated 10/5/18, passed by the court of the Session Judge Dibrugarh in Sessions case number 52/2016, by which the appellant has been convicted under section 302 IPC and section 201 IPC. So and so, okay, same thing.
T Begum.
All right. Yes, sir, Yashodri does the appointment. Legally counsel.
Judgment
Legally. Amicus.
dated
Amicus.
29/2/2023, passed by the court of the Additional Sessions Judge bracket FTC-1, Margarita. In Sessions case number 39 bracket M/2019, by which the appellant has been convicted under section 302 IPC.
Yashodri
Name.
does.
ADAS,
J does.
JDAS.
Please, my lords. Lordships, basically, this is our appeal is against an order of transfer. The contention. is
Yes,
Challenge the order of transfer.
Mr. Chaudhary. He's got just 1 month, 1 year left. Plus he's been, last transfer was in, I think, December 21.
Lordship, that is true, but the exigencies of services to be considered by the
But
authority.
with
Lordship.
you see, because normal tenure is 3 years.
That is okay, Lordship.
Some reasoning should be given,
No, no,
otherwise.
that is why he has been asked to file a representation, which will be disposed of by a speaking order, Lordship.
But you see, last few, unless there is something really compelling, I mean, some.
No, Lordship, since it is not done at the local level, it is done at the DG level, Lordship, there is something. Therefore, he has been.
You bring us that something, you give us, maybe then we'll decide. Because otherwise,
Lordship will keep it after a week, Lordship.
we'll keep it for a week.
Lordship, then.
Heard, Mr.
As they, your lordship.
As the learned counsel for the appellant, who submits that the petitioner has been transferred by impugned order dated 29/5/2023 in violation of the standing order, as in violation of the guidelines of the CRPF, which governs transfer of its officers providing that 3 years would be the normal tenure of any posting. The petitioner's case is that he has been transferred where was that Chennai or something? Where is that? Which paragraph?
Lordship. Of the writ petition, your lordship, it is at page number 23, your lordship. Paragraph 3.
Submits that after being promoted to the post of commandant, the petitioner was posted at Avadi, Chennai. On 9/6/2017. On 31/12/2017, the petitioner was posted at 97 Battalion, RAF (CRPF), Avadi, Chennai. Thereafter, the petitioner was posted in the office of the IGP, Odisha sector at BBSR, Odisha. After on 22/2/2019. After completion of 2 years, the petitioner was transferred to 156 BN, CRPF, Kukurmari, Daligaon, Chirang district, Assam on 4/12/2021. Though the petitioner is to retire on 30/04/2024, the petitioner has been issued the impugned transfer order dated 29/5/2023, even though he has less than 11 months of service. On considering the above facts, this court is of the view that the reasons for the said transfer should be brought to the notice of this court. Accordingly, Mr. R.K.D. Chaudhary, learned Deputy SGI, is granted a week's time, 2 weeks time.
Let it be on Monday, next Monday, Lordship.
Is granted a week's time to obtain instructions in this matter. List the matter on next month, list the matter of session. In the interim, the impugned order dated 29/5/2023 and the judgment and order dated 29/5/2023 passed in WPC 3058/2023 shall remain state till the next returnable date.
Lordship has only to consider on what administrative exigency he has been done. So that is in 6 of the rules, page 39. Because the DG has the power to relax these rules on administrative exigencies. If the
No, it's
records
okay.
reveal, if the records reveal.
No, it can, you see, that we have no quarrel with that. Only thing is we want to know what are the reasons,
Yes,
should be
yes.
germane reasons.
Yes,
You see, some humanitarian conditions
I
required.
do,
Yes, 11 months or so is got left.
I do. Relax, Lordship.
List the matter after a week, don't give a date. Better.
Most obliged.
This is a matrimonial appeal.
Item,
Item 6.
yes,
In spite of our best effort, we could not contact the petitioner also. We have written letter to them, the local council
so
also.
we
tried-
dismiss it.
And local council also could not trace out his address.
So, you could not trace out,
His address of my client was.
you could not trace out the address of the client, you
Yes,
do
I
not
got
have
it.
the phone number of the client.
Probably he is not available in Silchar also, the local council.
Probably he's not giving the money also.
Probably Lordship. And Lordship, on respondent, we took steps on many occasions, but she also.
Now you have taken step only one.
No, Lordship, we have taken on 5 times. Thereafter, we have directed to take notice through Dusty. We sent to local council.
Probably he's paid the money. Maybe execution court must have been seized of the matter.
Lordship, probably in local council also, he is went his
You know,
junior.
we have noticed that the impugned order was passed in 2014,
Yes, Lordship.
but it has been registered only in 2018. This
Because
case.
there was a delay, Lordship. You can refer
There's a
that.
delay. Or was it under objection before the registry?
Yes, Lordship, there was a delay, but in spite of service of notice, the respondent didn't appear. So this
Was there any defective filing?
No, Lordship, there was a delay
Delay.
in filing the appeal. And now,
Okay.
Lordship, there is no error, we could not trace out the appellant also.
Okay. Heard Mr. S.C. Kher, learned counsel for the appellant, who submits that that he cannot contact the appellant, nor does he have the correct address of the appellant.
We are having address, but he is not.
I said
receiving it.
correct address.
Yes, sir.
In as much as the communication being sent to the appellant in the address given in the cost title is not being answered to by the appellant. First step.
In the Lordship, local council, he could not trace out.
He also submits that the counsel that had represented the appellant in the trial court
Yes, sir.
could not be traced out. And as such, he has no further comments to make in this case. Full stop. Next para. This appeal is preferred against the judgment and order dated 9/6/2014, granting divorce sought by the appellant and directing the appellant to pay the respondent a lump sum amount of rupees 4 lakhs only as permanent and future alimony, and the sum of rupees 3,000 per month for maintenance of the minor daughter till she attains the age of majority. Full stop. The said judgment dated 9/6/2014 was passed by the principal judge, family court, Kachar at Silchar in FC bracket civil bracket close 158/2012. Full stop. The appeal was filed on 30/09/2014. No, 30/09/2014. Full stop. Though notice had been, those steps for service of notice upon the respondent had been taken, had apparently been taken earlier, the notice was returned unserved. Though dusty service was also permitted to be taken by this court in the order dated, wide order dated 25/7/2022. No steps was taken in this regard. No, in the said manner, by the appellant. Full stop. Next paragraph. This court, in its order dated 17/1/2023, had given another opportunity to the appellant to take steps for service of notice upon the respondent, failing which the matter would be dismissed without any further order. Full stop. The appellant was also directed to produce on the next date of listing, proof that rupees 2 out of the 4 lakhs had been paid by the appellant to the respondent out of the permanent alimony to be given to the respondent. Next para, as stated in the foregoing paragraphs, comma. No proof of payment of 50% of the alimony has been shown by the, no, not has been shown, can be shown by the counsel for the appellant. Full stop. Further, as stated by him, further as stated by the counsel for the appellant, comma. The counsel has lost touch with the appellant. Full stop. In fact, while order dated 28/2/2023, this court had further granted 4 weeks' time to the appellant to take steps for service of notice upon the respondents. Upon the respondent, full stop. The same also has not been done in view of the reasons stated above, comma. Accordingly, comma, we are of the view that the appellant is not interested in pursuing this matter any longer. The rate appeal is accordingly dismissed.
Mate appeal.
Huh?
Mate appeal, matrimonial appeal.
The matrimonial appeal is accordingly dismissed
Not appeal.
for non-prosecution by the appellant.
Much appeal.
बाद में। अच्छा अभी दे दो होगा लगा दो अच्छा What is this item? 7. What to do? No one has come. No one appears for the applicant on call. This is a matter of the 2 weeks.
In this matter, service is awaited upon the sole respondent.
Huh?
Service is awaited upon the sole respondent.
So how long will we wait?
Lordship may, I'll pray for a fresh step, Lordship. I don't know, Lordship, it may get somewhere low, maybe. We'll take fresh steps, Lordship.
Dusty, what about Dusty?
For that, Lordship, I put it because it is a matter in Lordship and there is no, they are not staying together or.
Huh?
I have to take instruction regarding Dusty, your Lordship.
Y'all are from the same area,
Same area, Lordship, but I don't know.
Same
Lordship,
police
what
station,
relationship they have.
same village.
Yes, Lordship, but I don't know what relationship they, I have to take instruction, Lordship, after 5 minutes, Lordship.
Not really.
Taken up.
Huh?
I can take instruction from the petitioner, your Lordship.
Okay, you have 10 sections. They will take it up. Otherwise, there's no point. Again, this.
Yes, Lordship, that's true, Lordship, it's time consuming otherwise.
Waste of time.
May I please your lordship. Lordship, I have got new address of the sole respondent lordship. So kindly leave may be granted for taking a step, lordship.
What is the new address?
Lordship, landlord is the same lordship, house number has different lordship.
Our number is different.
Yes, lordship. House number and byline is different lordship.
Okay, right. Heard Miss
Jai Kolita.
J. Kalita, learned counsel for the appellant, who submits that she may be granted how much time?
Lordship, within 3 days.
who submits that she may be granted, who prays that she may be granted 3 days time to take steps for issuance of notice upon the respondent on the new address of the respondent. Full stop. She submits that the new address of the respondent would only entail correction of the lane,
How- House number and
correction of the house number and
by landlordship.
by lane, comma, that is, the house number would be
House number will be 81. Sorry, lordship, 15, 15.
15, and the by lane would be
By lane,
inverted commas, right?
by lane lordship, Srikanta Dattapat. Srikanta Dattapat, house number 15.
Srikanta Dattapat, you got it? Right. The prayer of the appellant's counsel is allowed. Steps to be taken within 3 days for service of notice upon the respondent number 3 on the correct address, list the matter after 4 weeks.
Obliged.
Yes, is paper book required?
Lordship,
Is required?
has arrived.
Yes, here is arrived, so that's all. Okay, right. Heard Miss Barnali Chowdhury, learned amicus curiae, and Miss
Barnali Bhuya,
B. Buyar, learned PP,
APP.
learned APP. As LCR has arrived, registry to prepare the paper book and list the same after preparation of the paper. And list the case after preparation.
the office and have you checked? Office note is there, your lordship, I could not check.
What?
Cause this is showing with office note, my lord. LCR has
Office-
been replaced.
LCR has arrived, it's in the
LCR
causes.
has been replaced.
The causes is showing that.
No, some office note is there. your lordship.
Records have been received from the sessions court censor, white censor,
My lord. Would like.
Lordship, I apologize, Lordship, but I have taken instruction from the client, Lordship, he said that there is a high possibility, Lordship, if he goes to that house, there is a high possibility there will be a chaos, Lordship.
There'll be a
And he has
chaos.
no, and he has no contact with any of the, means like, any persons, Lordship, of her.
Okay, right, in that, which item is yours?
Lordship.
Which
think
item?
Eight,
Item 8, right. Mr.
DJ Das, your Lordship.
DJ Das appears for the appellant. As there is no return of AD card or unserved notice
Fresh steps.
from the respondent, fresh steps should be taken by the appellant within 3 days
Lordship.
for issuance of fresh notice to the respondent. List the matter after 4 weeks.
Lordship.
Yes, paper book is required or not?
Yes, my lord,
So same order,
yes.
okay. Out here, the name of the amicus would be T. Begum.
Yes.
Obliged.
So madam, here was same thing. Paper book,
Here, I think they have not taken the notice,
who has not taken the note?
the petitioner side for service of notice on the respondent.
Lordship, we have
I think-
taken steps on 2/5/2023. Registry may verify this, we have taken steps, your lordship. On 2/5/2023, we have taken step to respond and go to your lordship.
Notice is issued to the respondent number 2.
Acha, acha. Then we can await.
No. Notice was to be issued.
Acha, huh.
No steps
Steps.
taken.
No
Yes,
steps.
lordship, we have taken
When?
steps On 2/5/2023 in website, it's available, Lordship. We have taken steps on. Registry may verify this one. After that,
Why don't you also verify?
Lordship, we have verified, Lordship. We have taken steps on
Is there
website.
any slip you have you
Lordship,
downloaded any slip?
Not with me now, but we have verified on website. We have on.
So you download that in the website,
Yes,
take a
we-
screenshot.
Yes, I have a screenshot, Lordship, with my mobile, Lordship, but we have not printed out, Lordship.
You go and print out. We'll wait for you. Go and print it out.
Deep
Go and print
domain,
it out.
deep domain.
Go and print it out.
Next matter, here on the last occasion, I was supposed to inform the informant about the case and if they are agreeable to appoint some advocate, then I was supposed to apprise all
Which
those
one?
facts.
Item 14.
Item 14, but somehow I've spoken to the OC of that respective police station. But it's not done. I think I need 1 week's time. I'll do this. I'll
For what?
apprise. I'll apprise the respondent that a case has been filed here. There's an
Okay,
order
or
of the
you're
honorable
supposed to do it. Huh?
And 1
Ask for
week's
Dr.
time,
Kindly fill.
I spoke to the OC, but there's something wrong. I don't know. Within 1 week's time, I'll comply with this order.
Okay. Miss El Jahan, learned additional PP. Needs a week's time to obtain instructions from the SHO, from the OC,
Yes.
from the OC. Which police station?
Which police station? I forgot. Was, Dima Hasao, I think. Or
Please
Karbi.
check, please check, please check.
Lordship. Which police station? Half long. Which is half
From the
long.
OC Haflong Police Station. With regard to whether the victim as well as the complainant have been informed of the pendency of the present case. This is the matter after review.
Next Monday, yes. This is that Hemaji bomb blast matter where number of children died.
Number of,
Children's died.
Oh.
They went for the Independence Day parade, 15 August.
when that person comes, with the note, we'll bring this. Put it here.
My lord, this is quite an old case.
Huh?
Incident relates to 2004. On the Independence Day, there was a bomb blast in a public building, which resulted in the death of 13%,
30% died,
13,
1-3.
and some more persons got injured.
2004, August 15,
August 15.
August 15, 13% died. So how many appellants are here?
My lord, in item number 15, there are 3.
Item number 15, where is 15?
And 16, there is 1.
Ah.
17 days. Oh, and next item also there is 1.
So in criminal appeal, criminal appeal 311
311,
of 2019, there are 3
3 appellants.
appellants.
Example 305 of 19, there is one appellant. I am representing him.
In 305
There is one appellant.
of 2019, there is 1 appellant.
I am representing him. And criminal appeal 365 of 19, there is also one appellant. But the counsel is not here. But his jail term is for 5 years anyway. Other 2 appeals are of life sentence.
I think there are 6 appellants in total.
No.
And one appeal is not listed before me.
Already term.
Oh, that's term is
okay.
over.
There was another
Start
appeal
the
actually.
term.
He was not given bail. There's a jail term of 4 years. He was not given bail. During the pendency of this appeal, his term got over. So that was the practice.
So now these appellants in the first case 311,
Yes.
they have been convicted under what section?
Almost all the sections will have 302, 120P, thereafter 323 of IPC. And then, my lord, under the Unlawful Activities Act, section 10BI and 13(1)(a), and then under Explosive Substance Act, section 3 and 4. 3A and 4.
And this 305 of 2019
Same.
Same. and in the 365 of 2019.
365 minor here is only under 323.
Huh?
No, only under 323.
323.
323.
So we can leave that aside for the pending.
Yes. And 309 is already in practice.
So 365, since the
In
council
fact,
is not here, we can.
Here's Tamil over.
Tamil is over.
305,
309.
365, for how many years has he been?
He has not been in there for maybe some few months. And on the, when the appeal was admitted, he was granted bail. 365.
Okay, so he has hardly been in jail.
Maybe some few months. And as of 309, he has served his term. That was maybe 4 or 5 years. He has served his term.
5 years.
No, 365, he has been convicted under section.
And,
10 and 13 of UAP. 10 and 13 of UAP.
So
Hemen.
his term is not complete.
Hemen Gogoi. Hemen Gogoi is, Hemen Gogoi is convicted for 2 years under section 10 of UAP.
Hmm.
And 4 years under 13 of UAP perhaps.
That's one.
Yes,
4 years, total is 4 years.
Concurrently.
Concurrent.
concurrently, all concurrent.
It was all concurrent, and so has he completed the term or is out of it? No,
He is on bail.
he's on bail. So you are, and you all are,
We are in jail.
all of you all are in jail.
Yes, in 311, all are in jail.
And 305, is the 309, there's 1 person in jail.
Then you write in that item 17. You write. No one appears for the appellant. Accordingly, list this matter. Accordingly, detach this matter from the other cases and list this matter after a week. Okay. Then we'll take up 311 and 305.
Yes, no, from the same judgment, one hearing will cover both.
So where is the paper book?
Paper book is in 3 volumes, my lord. Volume 1 contains the evidence and 1, 2, 3. Here's the 313. Well, a number of witnesses are quite big. We'll have to marshal about 60 witnesses,
How many?
about 60.
60.
And the documents are in 2 volumes.
My one. Quite a bit.
But because it was unnecessary, my lord. The same type of evidence is coming. I don't know what is the idea behind. It's quite unnecessary according to me, my lord.
Okay, so
My lord, I can straight away go to the evidence, my lord.
no, let's go to the FIR first. Yes, step by step.
FIR's comments at page 1.
Page 1,
The content part your lordship will get at page 3.
just a minute. Page 1, yes. FIR dated
Dated 17/8/04.
17804, yes.
15/8/2004, sorry. my lord.
Huh? It says 17.8 out here.
17 is the date.
Acha is the date of the, uh-huh. Is the date of?
Magistrate signature.
Okay, 15804, what does it say?
I have the honor to state that about 8:55 PM today, that is 15th day of August 2004, while I was doing law and order duty
That was.
in the playground of at page 3. my lord.
You give 1 set to me and 1 set to him. No, you give me that. What is?
Yes.
Law and order duty in the
15/8/2004. August, 8:55 AM.
8:55. While I was doing law and order duty in the playground of Demaji College, where the Independence Day celebrations were going on, a time bomb which remained buried from before under the ground to the east of the parade ground prepared for Independence Day exploded, killing so. Another 13. During investigation, the next page, Milord, next para. During investigation, it is learned that United Liberation Front of Assam, a militant outfit banned by the government of India, had exploded the bomb containing very powerful explosive materials in order to create an atmosphere of terror by killing and grievously injuring the innocent civilians. Moreover, the members of this militant outfit, in order to create an independent nation, have declared war against the state and are engaged in this sort of subversive activities, thereby posing threat to the sovereignty of India. I therefore pray the good self-transfer. On this basis, my lord, a case was registered under 120B, then 121, 121A, 122, 302, 323 IPC, and Explosive Substance Act, Section 3 and 4, and then Section 10 and 13 of the UAP Act.
Charge, what are the charge?
Charges next page, my lord. All these people, firstly, on 15.
So there were 14 accused persons.
14, yes.
Rakesh, put off AC.
The first charge is under 120
Put off the fan.
IPC.
Put off the fan. Fine. Yes,
Yes. The first charge is under 120B, criminal conspiracy, IPC. Second charge is under 302.
yes,
Third charge is under 326 IPC. He was hurt by dangerous weapon. And fourthly, 323 IPC. Fifthly, under Section 3 of Explosive Substance Act. Sixth, Section 4 of Explosive Substance Act. Fifth is seventhly, my lord, it's Section 10 of UAP Act. Eighth, 13 of UAP Act.
yes.
Yes. However, I think we can stay to have a look at the evidence. PW1 at page 9. The Project Director DRDA Dhemaji on 15/8/2004. I was working as Project Director DRDA Dhemaji. On that day, I sent the dead bodies of the victim died in the bomb blasting case at Dhemaji College to Dhemaji Civil Hospital for performing post-mortem examination. Exhibit 1 to 13 are the dead body challenge of the accused and so. PW2. On 15/8/2004, I was serving as ASI Dhemaji Police Station. While I was in the police station, I came to know that a bomb blast had taken place at Dhemaji College Field around 8:30 of 9 o'clock. I did not go to the place of occurrence. I learned that 4 children have died and a lot of people have been injured and have only to this much to say. So this evidence takes us nowhere, my lord, nothing. 3. It's the person who carried the dead bodies. This is the page 13, my lord. PW3. I know the accused person on 15/8/2004, we found Red Cross took place people who had got injured in the bomb blast to Jamaji College Field to the hospital. We also carried the dead body.
Look, one thing, there is how many witnesses? 60, 58.
58 PWs, 2 DWs.
So do we read all the, is it relevant to read all the
My lord.
depositions?
According to me, we have from 1 to 16, on to 15. Your lordship can straight away skip because the same thing they are saying, incident happened. I do not know what happened.
Hearsay,
1 to 15.
1 to 15 is hearsay.
Yes. And 16 may have some relevance, my lord. Your lordship can,
So let's go to 16 then.
yes. Page 38. I know the accused person. The incident took place on the 15th of August 2004. I was in my home that morning at about 7:30 AM. I heard a loud sound. I saw people running here and there. Afterwards, I learned that a bomb blast had taken place at Jamaji College Field. A lot of people sustained injuries. Some people died. Later, during investigation, the police called me to the police station. In the police station, accused Jotin Duari was narrating before the police as to how the incident had been given effect to. I was present at that time. Video recording was done. Police seized one mobile phone in connection with the incident. I do not remember things stated by Jotin Duari to the.
Who is this Jatin Duari?
Jotin Duari is one of the accused.
Is he one of the appellants here? One of the appellants.
I do not remember now the things stated by Duari before the police. I do not know from whom the police mobile phone was seized. It is not a fact that Jotin Duari had not narrated before the police as to how the incident had been given effect to. I do not remember the things stated by Jotin Duari. It is not a fact that I have adduced evidence. Now, he talks about a statement made to the police officer during investigation by an accused. Obviously, that is inadmissible. my lord. I may just point out, my lord, now he's talking about Jotin Duari.
Hmm?
Now, his statement was also recorded under 164.
Whose statement?
This witness, my lord.
Jatin Duari.
Yes.
164.
No, no, the guess.
Huh?
This witnesses,
This witness
yes.
under 164.
There he says a different thing. He talks about, he doesn't talk anything about Jotin Duari, but talks about another person, Dipali Borgohain.
Statement under 164 or 161?
161 statement is there, my lord. In addition, they have recorded under 164.
Okay.
So that also, according to me, my lord, in my humble submission, has no relevance at all because it's a statement of the witness. It cannot be acted upon. It's not admissible. The only purpose is that it can be placed before him to confront or to corroborate. That is not done. Straight away, they have only produced a statement. Even otherwise, my lord, if your lordship considers it cannot be acted upon. In one stage, he talks about someone else. Now he comes and talks about something else. And he also says, that I do not remember what was stated. What is relevant is the statement which the accused made before the police. Of course, that is inadmissible, my lord. But then somebody making a statement before the police, that is what he says. Where is the statement? We don't have it.
Okay, next.
And that 164 statement was proved by the IO, not by him.
Huh?
The maker of the 164 statement is this witness. But the proof not by him, your lordship has seen the evidence.
Page,
He
Page-
has not, this witness has not proved this statement.
and where is that page? Let us see which page, which page is it? The 164 statement,
Exhibit 28 at page 562 of volume 3.
5, 6.
That will be volume 3.
Volume. Okay. But
562.
Volume 3. Page 560.
No, 562.
Not two minutes, just.
And you will get 674.
Huh?
670, page 670.
674.
Right? 674. Yes. I am the Gaumbura, as your lordship got it.
Yeah.
sir. I am the Gaumbura of single lot covering 3 villages. On being called by the officer in charge of Dhamaji police station, I visited the police station yesterday, that is 10/10/2008. I think there is something wrong, my lord. It can't be 2008. Incident happened on 2004. And his statement was dated 11th of October 2004.
Show me, you see, this is the, whose statement is this?
This is PW
63.
16, sorry. No.
Huh?
PW 16.
Okay, so this is the 164 statement of PW 16,
Yes,
674.
Yeah.
Now, where exhibited when? Where is the exhibit?
exhibit is 56.
In whose evidence? Hearing whose evidence? Evidence of.
Only the IO.
Only the IO. So it was not exhibited by PW 16. It cannot be acted upon. That's all.
It cannot be even otherwise, my lord, it's only a statement of a witness. It's not.
Unless there is cross-examination. it cannot be done.
And confronted with, yes. Plus, he says. It comes with a different story altogether. And what he says, that somebody, one of the accused persons were making a statement before the police was present. That again is hit by section 25 of the Evidence Act, inadmissible.
Next then, no, this was made by whom? 674. By a magistrate or
Magistrate,
Before mentioned.
before a magistrate.
JMFC, okay. Then, okay, the next, let's go to the next.
Next is 17, no, 18.
17, is it relevant?
Not relevant because. Not.
17 is, then it's 18, is it
I
relevant?
think we better, my lord, your lordship. I may think there is nothing, but your lordship may find something. Right, skip. No, yeah. No, very evidence.
Okay,
That is at page 40.
okay, Mr. Council, you see, I've been asked to get up after every 50 minutes
Because of the pain.
back, yeah.
Yes.
So now, so I've decided that every 1 hour I'll just get up. Just for around 2-3
That's good
minutes,
for
or
us.
so then I'll come back.
That is good for us.
Lordship
also.
health is
Good for you. No, it's bad for you because you all are standing most of the time.
important.
We are sitting, so it's anyway.
Item 17.
Why, D-Tech for this, it's not going to know.
কৰি দিয়া লগতে। আপুনি কৰি লওক পিছত। কিনো আছে, everyone will go out. এইপিনৰ চাউণ্ডটো একদম ইপিনে নাযায় না ভালকে। ফেন চেনবোৰ অফ কৰা।
The appellants here in this case,
One is Milord. Dipanjali Borgohain.
Dipanjali,
Yes.
Dipanjali Borgohain,
Then Leela Gogoi, alias Khan,
Leela Gogoi,
Gogoi,
alias,
Khan,
huh?
Leela Khan.
Leela Khan,
And three is Jotin Dori.
Jatin Dwari.
Yes.
Okay,
That is in appeal number 311.
Huh?
These three appellants are in appeal number 311.
okay.
In appeal number 305, it's Muhi Hendik.
What is his name?
Muhi Hendik.
Spelling?
MUHI space HANDIQUE.
Handik.
Hendik. I am for him. And appeal 365, there's one Hemen Gogol.
No, 365, we are not, because the council is not here.
The council was here.
He came
Huh?
sometime back.
He came little
He came
later.
sometime back
He
actually.
came.
He came sometime.
Then why did he leave?
He'll be coming, I guess.
And Prashanta Bhuya.
That may appeal is infractions.
Prashanta Bhuya আছে নাই?
That's good. That's good.
I'm over.
That's
Kamila period 17. I know Ekus Jiten Sutia, Josh, Ekus Joya Sutia, and Ekus Apsara Bora. I do not know the other Ekus persons. The incident took place on 15th of August, 2004. At that time, I was studying BA second year, Dhamad College. On 15th August, there was a bomb blast in the college field. A lot of people got injured in the bomb blast. Some person died. Police examined me with regard to the incident.
Oh, how is this relevant? No relevance.
These are the type of evidence your lordship will get most of the evidence. What will be ultimately relevant is the IO.
No, just take us to the relevant witnesses.
Okay.
You said
Next,
18, 17, W 17, page 42. Is it relevant?
42, no, not, no.
Acha, he's the same person.
Much.
PW eighteen, PW
Then
eighteen, what he
18,
said is he
maybe
went with PW 16 to police station and he heard Jotin and Dipanjali giving statement to police. This is what he said.
But what were they exactly saying? He doesn't know.
He doesn't.
He does not.
So
know.
he is also of no
Not
relevance.
English.
Then 19 is a nurse who was present in the field. She escaped unhurt. Or she escaped and she was hurt.
So how does that?
No, it's not relevant, below, or I think your lordship can come to 30, PW 30.
30.
It will even know anything.
Hemen Gogoi is a brother-in-law.
Yes, I'm just giving my lord.
56.
56, my lord. I do not know accused present in the dock except Chandra Nath Gogoi and Hemen Gogoi. They are my husband and brother-in-law respectively. I do not know Ahmed Ali. It was in August 2004 when I had signed the seizure some days prior to the signature about 4-5 boys came to our house at about 10:30 PM. I do not know any of them. They wanted to have food at our place and had threatened that if food was not given, we will face dire consequences. So we came, gave, I think it will be gave, we gave them food. They
So
went away.
how is this relevant?
That is also not relevant, my lord. 31 is Minu Gogoi.
Because I think one of the boys is Jutin Dory, no?
What is that?
No, 4-5 boys came to their house.
Huh?
4-5 boys came. And doesn't name anybody. Some boys.
So how does it matter? Some boys came. It says some old men came also. How does it matter?
They possibly had.
That- 31 is also same type of evidence, my lord. 35 to Noi. 34. Your lordship may see 34. They talk about seizing a cassette. I am presently serving at SP Office Damaji. I do not know the accused persons.
Page 60.
60. I am presently serving as SP Office Damaji. I do not know the accused persons in the dock except Jutin Duari and Dipanjali Borgohain. I know SI Ahmed Ali. The incident of.
Okay, okay. Just a minute, Mr. Counsel. We'll just complete his case. Yes.
We are 17.
Yes. Acha. Yeah, for for 17. So you're ready.
I am ready today.
Okay, good.
Under my senior will complete my after my.
Yes. Sir.
I have it
ठीक है।
in court number 9.
Okay.
I am after,
Huh?
after doing that case one court number 9.
Okay, okay.
And senior complete that.
Yes.
After the bomb blast was taken for a video recording during the house search of Dipanjali. Dipanjali is an accused, my lord. The search was recorded by Ahmed Ali, 4 cases from me. I had signed the seizure list. I have done the video.
No, what do you mean? Search was recorded and Ahmed Ali seized 4 cassettes from me.
Search was done by Ali. And he is the man who recorded it. The search operation was recorded. There
So
also,
the SP,
he is.
he's a, what is he? He's a government servant.
Yes, my lord. ऐसा न हो जाने. He was a superintendent.
So how is this relevant?
That is also not relevant actually.
There's nothing relevant out here.
I think 35. police voted.
35 is Mahendra Kumar. I do not know the accused present in the dock. I do not know SI Ahmed Ali. I do not know anything about the blast. Only heard about it thereafter. Police had brought me to the court and my statement was recorded by the magistrate. Police told me what to say before the magistrate. Exhibit 30 is.
Police told me what to say before the magistrate. So his statement, whatever it is, goes.
It goes.
Let us see this exhibit 30. Anyway, where is it? Which page?
My lord, page
Exhibit 35.
566 at volume 3.
Page 566. Page 566.
At about, has your lordship got me, lord? Relevant part is at 5:67. At about 7 o'clock in the evening of March 2004, Muhi Hendik took me by his vehicle to the house of Meena Bodwa and at Bhapara in order to get me acquainted with the person. I asked the name of the person, but Mohi Hendik didn't tell the name. Mohi Hendik dropped me before the reaching the Meena Bodwa's house and entered to small bylane to bring the person, telling me to proceed to Meena Bora's house on foot. Meena Bora is my friend. Some 10 minutes after that, I had reached Meena Bora's house. Mohi Hendik reached Meena Bora's house, taking along persons introduced as Mr. Bharali. Mohi Hendik told us that he was a member of organization and would chat with us for a couple of matters. When we asked about the matter, the person told us that they were kind of person who treat people kindly and bad people without mercy. He also asked as to whether he reads the newspaper or not. He asked us to fulfill three conditions as we were shared good rapport with Bharat Moro. Bharat Moro, Bharat Moro is the minister, Millard, he is PW 45. If Minister Bharat Moro takes the risk and communicates with the government, and if the terms of negotiation are acceptable to them, then they will surrender. See, if Rani Narok gets elected as member of Lok Sabha, she must raise demand for plebiscite in connection with Alpha's demand for Assam's independence. The road from Kanibil to Lalung Tinali and from Batikur to Penso should be restored in good condition. Then we, that is Meena Borua and I replied to him in the affirmative. We were frightened when we spoke. We were asked to convey him the result of our conversation with Bharat Moro. He told us that he would telephone us to ask the result. I have friendship with Bharat Moro since my childhood. Meena Borua also shares good report with Bharat. We therefore told Bharat Moro about the three conditions. Bharat told us that he would talk with Rani Nora. Thereafter, Bharali telephoned me twice on 2 different days and asked me about the matter. I then replied to him in the affirmative. Thereafter, about 10 a.m., one day during the time of election in the month of May, the Minister Bharat Nora asked to that person Bharali over mobile phone in presence of a lot of people. Afterwards, Nora told us that the said Bharali had threatened him in a very unsavory manner. I have no connection with regard to the giving of mobile phone. I had known anything later from the newspaper. I got to know about Joseph Bharali involved in the bomb blast of Dhamaji, who might be the said person, Bharali. I have nothing to say. So even if we accept this statement, my lord, there is nothing. There is nothing. Amar 35 as well, next to P as well. 36. 36 also he says he doesn't know anything. Mala.
Let us see what is his statement.
It's 572.
572.
570. Volume 3.
You see, what is this police and tortured me? Police had tortured me. The translation is
These
that.
translations are done in the office, my lord.
I know this is an actually original thing, but typographical mistake. Police
Whatever.
had- Police had.
And you see, there is a slight problem sometimes. What happens is the translation,
Yes.
it does not exactly match the words in the
Yes.
vernacular language. So that is a problem. And for important matters,
Yes.
we have got to go back to the original transcription.
I think this, the trial statements are original.
These are originals. Because
Original.
the signatures are at the side.
Okay.
Signatures are there.
This is
So
a
then the typographical
Yes,
error.
police had.
And it should be had. Anyway, page 572, correct?
at about 5:30 AM on that day, Vishwakarma Puja. That means, my lord, he is referring to the date 17/9/2003. Vishwakarma Puja on the earlier year, my lord, was on the 17th of September 2003. As I was taking my morning tea after getting up on the one youth identified himself as Rahul, entered my house straight away.
So he's talking of the year 2003.
Yes. It is 6 to Ekuna actually. My lord, we can straight away go to 55. In between, if there is anything against me, my lord, my
Okay, from
Lanet-
36 to 54, there's nothing.
absolutely nothing. I hope my friend will hear me out.
36 is hard.
Check out if there is anything.
39 is the doctor.
Doctor, there is this incident is not
39, let us see page
30.
39 is at page 83. Page 81.
65, 65,
65.
Huh?
65, 65.
65. No. He says the 36 to 54 are not relevant. So that means we have to go to 55 now.
55.
Yes.
So 55 is at page
106.
106.
He is the magistrate who recorded the statements of the witnesses. And also the one of the accused appellants.
Yes.
On 11/10/2004, I was working as judicial magistrate first class at Dhamaji. On that day, I was entrusted by CJM Dhamaji to record the confessional statement of accused Jotin Dwari. Is appellant number 3, Lord. According to the accused Jotin Dwari, and the relevant police papers was produced before me on 11/10/2004, and on being asked whether the accused was willing to make confession, he replied in the affirmative. However, to give the accused sufficient time for reflection, he was sent to the judicial custody, fixing 12/10/2004 for recording confessional statement. On 12/10/2004, again, as per the order of CJM Dhamaji, the accused was produced before me at 11:30 AM for recording the confession statement. On that day also, on being asked whether the accused was willing to make
So
confession.
page 106 is the okay, deposition. Okay, yes.
Of the magistrate who recorded
Yes,
the
yes.
confession. On expiry of the said 6 hours, the accused was brought before me, and on being asked about the accused, expressed his willingness to make confession. I cautioned the accused that he is not bound to make confession, and if confession was made, will be used against him in the trial. This apart, I have also told the accused that after the confession, he will not be sent to police custody. I also told him that whatever the statement he would make, it should be voluntary and true. The accused stated that he will make statement voluntarily without any coercion from fear of any pressure. On being satisfied that the accused would make confession voluntarily, I will record his statement under 164 CRPC in the prescribed format and appended certificate to the effect that the accused made his confession voluntarily. After recording of the statement, I read over the same to the accused, who admitted it to be correct. I observed the formalities regarding recording of confession statement. Accused Jotin Dwari under 164. I obtained signature of the accused. Dwari. I also recorded the statement of the witnesses Khoghen Borgohain on 5/10, Simanto Sutia on 8/10, Keshav Dihingia, Tilottama Chutia, Padmeshwar Chutia, and Bohagi Kumar. Your lordship may come to the cross part of it. Before recording the confessional statement, I did not ask the accused as to why he wanted to make the confession. While cautioning the accused, I told the accused that he will not make any false statement and what will be stated by him shall be the truth. I recorded the confession statement in my chamber. It is not a fact that I did not make the accused aware properly that the confessional statement made by him shall be used against him. I did not ask the accused whether he was going to make confession out of fear of police or torture or undue pressure. My lord, this sentence I'll have to use it little later, my lord. This is the first time this accused got the chance to retract his confession. He has given a suggestion to the recording magistrate that it was out of fear of police torture. Then comes the Ayog.
So where is the confession statement?
Yes, that we straight away come to that. That you will lordship will get at page 667 in the volume 3. In the first part is the format, Miller. That's 667 is the statement. In the evening hours of on 5/8/2004. That means he was referring to something which happened on that. Yeah, about 10 days prior to the incident. While I was at home, Alpha Kedar, namely Leela Khan, alias Leela Gogol, whom I know from before, Pintu Bora, Profulla Bayon, Rashid Ali, and Azan Nauk came to my house and taking me out of my house by threatening me at gunpoint. That's what it means. And may I read below? They took me to college gate to the front of the girls' hostel. After crossing our village as well as Tongonapara, they asked me to show the college field. I showed them the college field and thereafter they set me to hostel Tinali. As they had told me to wait there, I kept waiting there as they had threatened me not to leave my position till they allowed me to go. I kept waiting there. As they had threatened me not to leave my position till they allowed me to go, I kept waiting there for a long time. And when Leela Khan and Pintu Bora returned there at about 11 p.m., they threatened me to escort them to a safe passage, whereupon I escorted them through a safe route and stopped at the gate of my house. Thereafter, they left. I have only this much to say. I was a member of Alpha earlier. I surrendered to the government in the year 1997. Pintu Bora's house is at Lakhimpur, while Rashid's house is at Hilamar. So this is the statement which they call it a confessional statement. Confession has to be clear admission of the guilt of which the person has been charged. This is a matter relating to about 10 days prior to this thing. And he has as a matter of fact, exculpated himself. Where does he admit that he is guilty of this? offences.
So this appellant has shown them where the college field is.
Yes, that's under threat. That is what he says.
And the safe route.
Huh?
And the safe route.
He was
To his
put
house.
on that threat. And that happened about nothing emerges that he knew what work they are going to do. There's no admission to that. These people came, settled him, took him there, made him sit in the Buyada hostel. Thereafter they left. About 11 o'clock they came and took him and asked him to show a safe passage. That is what he obliged. That is the statement, my lord. So my submission is, where is the admission of the guilt of the crime which he has been charged with? It will be, from this statement, my lord, it will be presumptuous to think that this man knew that what the bomb is going to be planted. And the IO says, my lord, on this particular day, from his evidence, it emerges, on this day, the field was under guard. This field, which they are referring to here in the statement, was under police guard.
Police guard doesn't really help much, maybe.
That way casual job, my lord.
Huh?
But then at least I was not there in the field. I was made to wait in the, near the hostel. I waited there, my lord. What can I do? At gunpoint, they said me, knew that they were alpha cadets.
Anyway, this
Anyway.
Pintu Bora, Prafulla Bhuyan and this Rashid Barali.
Hmm.
And this, except for Leela Khan,
Yes.
the others are not appellants.
Others are appellant.
Huh?
My lord, this Pintu Bora is not an appellant.
Not even an accused.
No, he's not an appellant. He has been, he has not even been convicted. Prashanta Bhuya, he was convicted for 323, 4 years. It actually is infractuous.
Where's Prashanta Bhuya? I'm talking about page 667.
That Prafulla Bhuya is also Prashanta Bhuya, same person.
Huh?
Same
Prafulla
person.
Bhuya, alias Prashanta Bhuya. Is the same
Prafulla
person.
Bhuya and Prashanta
Is
Bhuya.
the same person.
So they are not an appellant.
He
He's
was
not
an
an appellant.
appellant.
Huh?
Prafulla Bhuya, he was an appellant in appeal number 365. But
Okay.
that has become infractuous actually. He has served his term.
365 is here pending here.
Sorry, ma'am, 309.
And what about Leela Khan? Leela Khan is here.
Is the appellant. my lord.
Pintu Bora,
Pintu Bora is not for your lordship.
Rashid Barali.
He is not for your lordship. And yeah, I am Muhim Hendik. I am not been named in this, not even been named in this confession.
Yes.
Then the relevant evidence will be, my lord. 56. 108. On 15/8/2004, I was posted at Dhamaji Police Station as OC. On that day, at about 6:15 AM, I made GD entries by number so and so dated 15/8/2004, as I was ready for law and order duty at Dhamaji College field area under my PS. While reaching near the Dhamaji College field, we heard a big sound and it seemed to be a sound of bomb blast. We immediately went to the college field and we saw a huge gathering of people and also found that some people got seriously injured in the said bomb blast. We also found that some people died at the spot. Then I immediately instructed SI Ahmed Ali to take the injured, the dead persons to the hospital for treatment, postmortem examination and inquest. In the meantime, I started the investigation. Due sketch map of the PO. After thorough investigation, it was found that altogether 3 women and 10 children died in the bomb blast. There were commotion and outrage amongst the people. And to control this situation, we resorted to tear gas and lathi charge. Thereafter, I rushed to Dhemaji Police Civil Hospital and took step to hand over the dead bodies to the family of respective members. Those who were seriously injured, they were shifted to AMCH Dibrugarh. As per my instruction, SI Ahmed completed the inquest and postmortem before handing over the dead bodies to the families. And then I think they want thereafter handing over the dead bodies to the family members. SI Ahmed lodged the complaint at the police station. I received the Ejahat dated so and registered the case number so.
Go to the relevant portion.
Yes. Huh? No. About 2 lines thereafter, during
Yes.
investigation,
Yes.
I could gather material regarding involvement of Leela Gogoi, Pintu Poda, Rosit Bharali, Silarai Gogoi, and Probin Bhuya, and recorded their statements. I visited the PO with forensic expert Nirmal Talukdar. I collected splinters and so Milord also can skip. No, I can take. During investigation, I could collect materials regarding involvement of Mohan Sutia and Prashanta Bhuya and recorded their statements. Yeah. And 109 about line about 6, 7 from the top. Your lordship can start from a motorcycle accident. Another accused, Gobind Chalu, as your lordship got it, my lord.
Yes.
Gobind Sahu was found involved in and accordingly was arrested. I also arrested Lokinath Bhuya, Nirup Lahon, Soruram Bhuya, and Puleswar Bhuya, selling his motorcycle used by the accused Prashanta Bhuya. The material of the articles collected from the PO were sent to FSL for examination. We also arrested accused Anjan Nev, found to be involved in the commission of the incident. One Gobind Chandra Kolita was apprehended by army officer, whether Ranbir Singh, and handed over to the police. From the statement of the accused Anjan Nev, it revealed that one Joy Chandra Sutia was giving shelter to Alpha members in his house. Accordingly, Joy Chandra Sutia was arrested. One mobile handset along with the SIM bearing number so and so used by accused Dipanjali Borgohain was seized from the possession. It is found that Dipanjali Borgohain used to make call to Alpha member Rosit Bharali in his number Iman, which was seized by the Samanta Sharma. Malu, what is the content of the calls? It's not on record. That has not been proved. The very fact that they allege that the number of phone calls were made. Also collection was made. I collected the application for form submitted in the name of Kuntu Sutia for getting the SIM. But it was found that the SIM was being used by accused Rosit Bharali. Accused Jotin Duari, Mohi Hendik, and Apsara Borua were also arrested, and one pocket diary was recovered and seized from Mohi Hendik. I produced the witness for 164 statement. Accused Jotin Duari expressed his willingness to make confession, and accordingly, he was produced before the magistrate in his accused Jotin Duari recreated the scene of the crime in presence of police officers. Investigating officer and presence of Muhammad Ali Mian ADC Damaji video recording was done and CD was made and the same was seized. Accused Joa Sutia was arrested during the investigation. It was found that accused Makhona Hazarika and Chandra Borwa was also involved in the commission of the incident, arrested in connection with some other cases. They were shown arrested in this case also. The documents relating to the mobile SIM used by accused Muhi Hendik and Dipanjali Vora were also seized. Also collected the call records relating to the calls made by using the seized SIMs. I also seized one Maruti car bearing number so and so from Ruby Hendik, wife of accused Muhi Hendik, which was used by Muhi Hendik for committing the crime. I also arrested accused Jitan Bora. I also seized written command direction given by Alpha leader Minal Hazarika to the members of the outfit organizations on being produced by the DC, by the OC, Kiosk police station in the district of Jorhat. This is not exhibitor also.
Where are you reading?
109.
109.
Nine. Your Lordship directly can come to the cross-examination part of it. He has only narrated the steps he has taken. Cross-examination part has assumed certain importance, my lord. I have not recorded the statement of Hundu Sutia, nor have I arrested him. Paper Exhibit 1 was not written in the letterpad of Alpha. Exhibit 1 does not bear the signature of the writer. It is not a fact that the statement of accused Dipanjali Borgohain was not recorded by two police personnel. I have not mentioned the address of witness in Exhibit 32, Subedar Singh apprehended Govind Kolita without any authority from our side. It is not a fact that accused Jotin Dwara was put to clear to make confession. This sentence, my lord, even before the IO, that was my case. You have put me to, that was the such, of course you will deny. It is not a fact that Jotin Dwari disclosed the names of some accused persons under duress. I have no knowledge regarding the contents of the pocket diary. I have not collected authentication certificate of the CD relating to recreation of the crime, scene of crime. My lord, the IOC is the pocket diary of Muhi Hendik. Now he says that I do not know what is there inside. Seizure of the pocket diary will not lead us to any inference, my lord, unless we know the content. That is not before the court. It is not a fact that the person whom the Maruti car was seized did not state.
Okay,
before-
anyway, basically, where is the evidence against the parents? Okay.
Nothing, if I have to say, my lord. Nothing at all is very unfortunate. Very, very unfortunate. A case of this nature.
Basically saying that they are alpha or something like that. Besides saying they're alpha, they're not stated anything much. It
That's an
appears.
opinion, my lord.
Huh?
That's an opinion. the
Whatever it
expected
is,
will-
whatever it.
See, I'm.
Is there anything to show that they were connected with the bomb blast?
Nothing at all, my lord. My learned friend will be able to, if she has any, of course, to us. Nil,
Some seizures and all, the telephone calls made by Dipanjali Borgohain. Lordship can just see the trial court judgment, the appreciation of
No,
evidence.
no, anyway, I think just let you finish.
Mhm.
I just wanted to keep that in mind.
Yes.
Because there appears to be nothing which appears to, connect them with the bomb blast. Okay. They might be alpha members.
Hmm.
They might be anything. But just because they are alpha doesn't mean that they were the one who had conducted the bomb blast.
Hmm.
Could have been anybody else. Or supposing the alpha consists of say 100 people or 200 people. if A, B, and C out of those 100 people had committed that bomb blast, can we paint all the 100 alpha members in the same brush?
We'll have to have evidence as against this person specifically.
That is correct.
Now, here, Jotin Duari's statement is kind of exculpatory as far as he is concerned. Leela Khan statement, as far as Leela Khan is concerned, it will be a confession of a co-accused, which is again a weak piece. So we need independent materials against these people. Somehow try to bring even the place where they had stayed on the few days before the incident. There also Hemen Gogoi and some people were there.
They were there somewhere. They were there together.
Uh,
But then, okay, they were there maybe thinking of doing some illegal act.
hmm.
But what is the connection between they staying there and the bomb blast?
Mhm.
I mean, there could have been another 80, 90 alpha members meeting somewhere else also. But how do you connect these particular alpha members to that bomb blast and not the others?
Anyway, I'll not reply today, Lordship, let me go through. Let me finish, let him finish. He has many things to show. And I'll reply tomorrow, day after, because I'll have to somehow link Dipanjali, at best Dipanjali, Leela Khan, Hemen Gogoi. Because
But
Jatin Duari-
Hemen Gogoi is, is not, there's nothing against Hemen Gogoi under 302.
302, nothing, only UAP. 10 and
Yes.
13,
If
terrorist act.
if 302 is not there, then how are you going to connect him with it?
UAP section 10, so terrorist act, I'll have to show that this was a terrorist act and he was involved.
Conducted by whom? If he was involved,
Hmm.
then 302 also should have been there against him.
Hmm.
Well, by that terrorist act, people had died. Why do you want to, exclude some persons out of the purview of 302 then?
Difficult case for prosecution because of the news that was made and some pressure perhaps. But I'll somehow try to cull out some evidence against these people. Otherwise, difficult. I know. There are no such evidence. These are the evidence.
How
But-
did the trial court?
Trial court
We
appreciation.
will have to appreciate the judgment. How did it come to a finding of guilt?
Hmm. Not many pages. Lordship can go to page number 4. It is,
Anyway,
yes.
let us finish. with
Lord.
first year purpose. We are finished with PW 55,
55, my lord,
56.
56. This sentence, my lord, about 10 days before till 15th of August,
Page 110.
page 110.
56 is the IO, correct?
My lord, that
Page-
sentence I'm
page
reading out, my
110.
lord. We are page 110.
Ah.
About 10 days before till 15th of August, Independence Day celebrations, we deploy security guard to guard the field chosen for 15th of August, the program. So as I was telling you, Lordship, the field was in guard.
No, this field, who was supposed to be the chief guest in this field?
That of course we do not know. Maybe that minister, Bharat Naro.
Maybe the minister.
Yeah.
So you see, it depends upon the importance of the chief guest, that the level of security is up there or, the normal security. is up.
No, no, was in the.
Not the chief.
No, not that this man.
No minister.
No, Bharat, no, it's there at page 112.
Next page, next 100.
112,
Please.
on the relevant Independence Day program,
Hmm.
witness Bharat Naro was attending Independence Day program at Lokhimpur.
This is Hemaji.
This is Amar.
That is Lokhimpur.
So we do not know who was supposed to
Someone
have
was there.
hosted the flag.
Anyway, it doesn't mean that just because there's security, that it cannot be breached. The very fact that there was a bomb blast shows that it was breached.
Yes, Mila. No, it is in the context of the 164 statement of Jotin Dori.
That
That 10 days prior, he was made by this person to threaten to accompany them and show them the field. The field was on the guy. Only for that purpose. It will be Kunai. While our next witness is also IO Melot, he is only submitted the charge sheet. Investigation was completed. by-
PW 57.
He is 57, my lord. He came later when the investigation was over and he submitted the charge sheet.
Is he's the IO also? No,
Subsequent.
he's
In a
the
sense-
second IO.
Second IO,
Second IO meaning, yes, he's the second IO
yes.
who submitted charge sheet.
I'll just read out the first part of it, my lord, just 4 sentences. I do not know whether the Independence Day program was held in Dhemaji College Field for the first time or not. I do not know regarding the derailment, deployment of security personnel in that field. I also did not know whether security personnel deployed to guard the field were examined in this case or not. On the relevant Independence Day program, witness Bharat Nora was attending Independence Day program at Lakhimpur. I had not recorded the statement of the police personnel who were present in the PO at the time of the incident. I have not collected the official report. It is not a fact that I submitted charge sheet against the accused person without any incriminating materials against them. This much, nothing else. FSL is your like, we are not disputed. Next. This next witness 58, my lord, is the FSL expert. Well, the incident has not been denied, so. Not
So it's neither here nor there. Page 113 is the FSL, what is he?
he is the
Retired,
senior scientific officer of director of FSI, Assam Kahilipara.
That time he was junior scientific officer.
Traces of RDX and PT and have been found in so and so. And these are not disputed.
that's all.
That's all, my lord. This is the type of evidence you will.
What about the 313?
Huh?
313 statement?
The 313 statement, yes, my lord, that is. Oh,
If I may point out one thing, my lord,
Not involved.
Muhi Hendricks 313 is not on record.
Huh?
Muhi Hendricks, whom I'm representing, is 313 is not on record. In fact, the paper book that is made by the registry, in the index also it is written 313 is not there.
Is it there in the,
I have not found it subjected to correction.
I'll see the case report.
okay, 313 is statement of,
Muhi Hendricks,
huh?
Muhi Hendricks.
Muhi Hendik.
But there's nothing incriminating against me to put in 313.
it follows automatically.
Oh, LCR is not here.
LCR, no, you call for the LCR.
LCR to 9.
Perhaps it's too bulky.
Yes, the problem is it's bulky. We'll have to put it somewhere here.
Otherwise, in the paper book, Muhi Hendricks 313 is not there. All others have said not involved.
But what was the evidence that was recorded by the trial court against them in the 313?
That is there. and from
Because
the-
prima facie, there appears to be, there doesn't appear to be much. So let us,
Volume number 3.
All
you can
given-
see from 487.
all 313 statements, the questions are the same.
Anyway, where is it? Which page?
So far as this man is concerned, Jotin Dore, that is at page 116.
Wait, 114 is DW one. What is DW one? What do they have got to
It
say?
had nothing to do with my opinion.
Huh?
Even for Hemen Gogoi,
Alibi.
alibi,
Okay, not in the house.
not for us.
And where is the 313 of the
Accused
Jatin Dwari?
Jotin Dore.
Page 116.
Huh.
Retracted confession.
First question is, my lord. This is where so and so, so and so, so and so, so and so, what have we got to say? I am not involved in the commission of the alleged offense.
But where is where is the question stating that you are involved in this bomb?
No, no question. That, there cannot be any such question, my lord. The only thing that was placed before us is 164 statement, which your lordship will get at page 132.
Okay,
Question number
just a minute.
132. Page, question number 44. Here that 164 statement was question on that. Confession statement. Was retracted by him.
Page?
Page 132.
Yes.
Yeah, my lord, the description that he was given time for reflection, everything. He was asked about 164 statement, what do you have to say? He says the police forced me to make the confession before the magistrate. I made confession due to fear of police atrocity. I did not make the confession voluntarily.
But
I'm
what
not-
was the confession?
Confession actually is not a confession, according to us, my lord. He says that 10 days prior to the incident, he was put to fear of it. At gunpoint, he was taken to
This confession is a page?
pages, my lord.
667, volume 3.
The one which your lordship saw in the evening hours.
There's a confessional statement of that jury.
667.
Here he retracts his confessional statement. The statement rather, I would say it's confessional statement. I am not involved in the commission of the alleged incident. Police threatened me with dire consequences if I did not make the confession. as taught by the police. The Lordship will kindly consider what does this statement reveal? Does it reveal that he is involved in the and he has exculpated himself, nothing to do with the incident? It will be assumptuous to think, you know, that this person 10 days later came and blasted the bomb. He doesn't say is anything with regard to the bomb blast. Only at gunpoint, he was brought to the field 10 days prior. This much Miller. If it has to be a confession, Miller, confession has to be an admission of the guilt of which he is charged. Oh. Mhm. If it is accepted by the court, Miller, it can only give a circumstance. And nothing beyond that.
Now let us see the trial court
Fine.
order.
ಇದು volume 2, that's fine. Go to volume 2, Miller. Page starts from page 441.
Relevant will be from paragraph 55.
Huh?
Relevant will be from paragraph 95, appreciation of evidence.
Pay for page
It
Page
starts at page 441.
441,
487.
487.
Your lord. The relevant, I'll take your lordship to the relevant part.
Okay, what we'll do is another small break and then we'll come back.
Nothing,
1 hour.
not.
You see, initially you should diligently comply with the doctor's orders. And once you start getting better, then you can,
Ignore.
yes, start to ignore.
Should not ignore actually.
No, it comes naturally. You start
Ah.
ignoring it, actually.
This
But
is-
since it is at the initial stage,
Hmm,
so at least we have got to,
yes,
try and
yes.
follow it.
If we start from page 493,
Huh?
Page 493.
493. Okay.
paragraph 118. Earlier, Miller, the court has recorded the statement of the
Right.
witnesses
Okay.
number wise,
So it's a lengthy judgment,
very lengthy one.
but the material operative portion is small, huh?
Not much. Miller. I have carefully considered the evidence of PWs on oath during trial and the statement of the witnesses under 164, as well as the confessional statement of the accused, Jatin Duwari under 164, CRPC. My lord, not just point out, my lord, in the later part of the judgment, the trial court has accepted that the 164 statement of the witnesses cannot be taken as a substantive evidence as part of the decision rendered by this court and also the Supreme Court. It has only a singular value that it can be put to the, in case he resigns, it can be put to the witness either for corroboration or for contradiction. Otherwise, it has no admissibility, it's not a substantive piece.
So what has the trial court held?
Trial court held below in the entirety of the entire thing. Below. A criminal case cannot be decided on that. There has to be pinpoint material.
How many confessional statements are there altogether?
Confessional statement only one.
Only one.
This the one which your lordship read.
Yes, only one.
Only one.
Of that Jatin Dwari.
Jotin Dwar.
And that also where he has shown the others where the field is located,
Yes. Which of course has been retracted by him later.
retracted.
Uh,
Was the retraction allowed?
Allowed definitely, my lord. If I'm put to fear, otherwise, my lord, there is no investigation will be required, my lord. Put into-
Retracted and allowed by order dated?
It's 313.
Huh?
It is 313.
In his 313 my lord, statement, my lord.
Huh?
In his statement.
Actually, in 313.
That is the occasion he can speak first. Of course, in cross-examination of the recording magistrate, I had suggested to him that I was put to fear. Then again, before the IO, he was cross-examined, that you have put me to fear.
Okay. Then page para 118, yes.
One. Carefully gone through, I have examined the evidence of PWs in respect of the seizure. From the cumulative evaluation of the evidence and the materials on record, it transpires that Alpha militants planted the bomb attack the bomb attack at the Damaji College field and engaged its active members in carrying out the operation. It reveals that the confessional statement of the accused Jatin Dwari that conspiracy was hatched to thwart the Independence Day program by way of bomb blast in the Damaji College field. On further scrutiny of the materials on record, it is found that the accused Jatin Dwari had played an active role in getting other active Alpha members to the college field and helped them to plant bombs in the college field. Though accused Jatin Dwari made confession implicating the persons responsible for conspiracy to commit bomb blast attack, that cannot absolve him as he was found to be actively involved in the said conspiracy. And this was apparent from the fact that the accused Jatin Dwari recreated the scene of the crime during police investigation, which should go to show that the accused Jatin Dwari was a party to the conspiracy to commit the attack. Recreation of the scene, my lord, nobody knows what was the scene. There is only one statement saying that he recreated the scene before the police. And that's of
He
course. in the statement-
recreated the same before the police.
Bearing in mind the rules of evidence as regards the use of statement of co-accused under section 30 of the Evidence Act, I may refer to the following observation made by the Honorable Supreme Court in the following cases. Kashmir Singh. It was observed as under the confession of an accused person is not an evidence in the ordinary sense of the term as defined in section 3. It cannot be made the foundation of a conviction and can only be used to support the other evidence. The proper way is first to marshal the evidence against the accused, excluding the confession altogether from the consideration to see whether it is believed, if it is believed, a conviction would safely be based on it. If it is capable of belief independently of the confession, then of course it is not necessary to call the confession in aid. But in cases may arise where the judge is not prepared to act on the other evidence as stands, even though if believed it would be sufficient to sustain a conviction. In such event, the judge may call in the aid of confession and use to lend assurance to the other evidence and thus fortify himself in believing what would the aid of the confession he would not be prepared to accept. Accused Jotin Tiwari, when examined under section 313 CRPC, stated that he made the confession under duress. Police forced him to make the confession, but it seems from the record that the accused Jotin Tiwari retracted his confession at a later stage. And of the trial, which can be said to be an afterthought. Moreover, the defense has not put forward any tangible reason to why it was not retracted at an earlier stage of the trial. I don't know what the trial code means. What stage should I have retracted? PW 55 is the first time. PW 55 when he tried to prove that first. That's the first occasion I was examining on that. When the accused can retract his confession? Taldo says that I did it at a later stage. There is no scope for any accused person. It will not be hard at any stage. Then, my lord, paragraph 121. So far as the use of reliability of retracted confession of the co-accused Honorable Supreme Court in so case, we wish to make it clear that this is only a repeat. What is so well established that retracted confession by an accused may form the basis of a conviction of the accused if it receives some general corroboration from other independent sources. It cannot, however, be the basis of convicting a co-accused, though it may be taken into consideration against the co-accused also. So, my lord, as your lordship has seen that minus that confession, my lord, there has to be some material corroborating what I have stated in my confessional statement. As discussed, we find that the prosecution examined PW 16, 17, and so, and these PWs has given statement before the magistrate under 164. These witnesses in that statement mentioned about the involvement of accused like Leela Khan, Leela Gogas, and so. Further, looking at the evidence of seizure, it is found that PW recovered the mobile handset with SIM card bearing number so and so from the possession of Dipali Gohai and mobile handset bearing number so and so from Mohi and Dick, which they used to make call to alpha leaders, Rosit Bharali and others, and also the daily call record of these mobile phones have also been collected from BSNL. Further, as members of the, as mentioned above, the IO PW 56 he recovered and seized one Maruti car bearing number so and so from the possession of accused Mohi and Dick. So it is clear from the materials on record that apart from the confession of the accused Jotin Tiwari, there are also other corroborating materials regarding involvement of Leela Khan, Mohi and Dick and Dipanjali Borgohai were actively involved in the commission of the blast. Now I had to,
Oh, okay, so basically the trial court has said that because of the confessional statement and also due to the recovery of that mobile
SIM card.
With which calls were made to the alpha leaders. And as one Maruti car was seized. Besides there being corroborative evidence. So they are guilty of the crime. And now, first of all, how do you prove that some act has taken place Because all this is not going to be done in broad daylight.
No.
It's all going to be hidden.
Yes.
Now, the bomb was planted in the field.
Yes.
And no one is going to say that I planted the bomb. So the only way to really connect is by what little evidence they have. Now, the only person who has connected with Alpha is this person, Jatin Duari. He's connected with Alpha and he has shown them where the field is. For what purpose was the field shown to the Alpha? We don't know. But appears to be only for the purpose of planting a bomb.
No, that is the initial impression that we have,
And then,
but that has to be material. And this happened about 10 days back, which I think is absurd. Man, why will somebody plan 10 days ahead? They say it's a time bomb.
so what? Time bomb doesn't mean that it has to be blown up within 1 or 2 hours. Can be blown up after a few days also.
Of course,
Evidence has to come, that can be done.
that is maybe possible, Milord. Just point it out. Or the first thing they have to prove that we belong to the Alpha cadre. Where is the proof? Except somebody saying that he may be an Alpha member. Where is the proof? And then comes the question of these people getting involved. What is the wrong with Dipanjali Borgohain? Some SIM card was recovered from her. And they say that with this SIM card, there was a talk with from this number, there was a talk with Rashid Ali, who that person thinks is a Alpha cadre. This much. So what is the talk all about? Maybe they were friends. They could have been anything. They would have been in love also.
Okay,
Could
yes.
be, could be
I
anything.
think we'll hear. I think, have you got anything to add?
I have
Say,
some things, small things to add, as a Muhi Hendik. I'll show certain things from the records.
you're for
Muhi Hendik, 30.
Moe Andy.
305 criminal. I'll submit that to people actually.
What do you have to add? Come. Because I don't think we are finishing today. Madam is going to take some more time.
Civil.
My lord takes up volume 2 first. Volume 2, page 495. That is the judgment.
Just a minute. Volume 1, yes,
Volume 2, page 495, paragraph 123. Page 495.
yes.
123. Further, looking at the evidence of seizure, it is found that PW 56, he is the IO, recovered mobile handset with SIM card bearing number so and so from possession of Dipanjali Gohai, and mobile handset bearing number so and so from the possession of accused Hendik, Mohi Hendik, which they used to make call to Alpha leaders Rashid Bharli and others. My lord, Evidence Act has changed its color in 2000. If anything is produced, electronic materials have been brought, 65B certificate has to be before this court. In this case, there is no 65B certificate. Even if the call records, the record is that.
No, another thing, even if they were speaking to this person, what were they speaking about?
Exactly, my lord. Exactly. That is the second leg. The
Just
first
a
leg,
minute, just a minute. Page 495,
para
para
1, 2, 3.
1, 2, 3. Your first argument is that
What was the context of
no,
the
no,
phone
yes,
call?
they have to provide
65B certificate as per the Evidence Act.
65B.
B capital B certificate for electronic records.
Yes, under what act? Under the
Evidence Act. I'll give citation to that effect, which is a mandatory provision. It cannot be bypassed.
anything else?
It is further, my lord, if I go down below,
Also, copy of daily call report of those mobile phones have been collected from BSNL. Same paragraph. Where is the BSNL employee who has come and said that this phone and this phone were talking?
Daily call report,
Daily call report of those mobile phones has also been collected from BSNL.
daily call report.
They have said they have collected it, they have not exhibited it. It's nowhere exhibited, the call reports. Thereafter, my lord, second line, further, as mentioned above, the IOPW 56 recovered and seized one Maruti car bearing registration number so and so from the possession of Muhi Hendik. In this context, in the
Yeah.
Your lordship got it? Thereafter, IO recovered of seized Maruti car bearing registration number so and so from the possession of accused Muhi Hendik.
Yes,
To correlate with that, I take your lordship to the evidence of the IO PW 56 at page 108. Relevant is page 109, volume 1.
108. Yes,
My lord,
yes,
1, 2, 3, 4, 5, 6. Seventh line from bottom. Page 109, 7 line from bottom. I also seized one Maruti car bearing registration number so wife, not from possession of Muhi Hendik. Wife of accused Muhi Hendik, which was used by Muhi Hendik for committing the crime. Now, my lord, committing the crime, what is the crime? A bomb was planted in the Dhemaji field. Is it their case that a bomb was taken in Muhi Hendik's car? If at all that is their case, have they sent Muhi Hendik's car for FSL? That is there anything found in that car that it was used? Is there any witness who has said that this car was loitering around the place of occurrence on few days before the occurrence? Has any witness said that any of the accused has fled in this car? So under what circumstances the IO says from his own that this is the car used for in the crime? Coupled with all this against Muhi Hendik, Jotin Diori's confessional statement, he says few persons, he's named some persons who had kept him in gunpoint and taken him to that to show him that film. The date is of 5/8/2004. There is nothing on evidence that anybody after that date till 15 had again gone to that field. Which means if the bomb is planted on that day, this car was supposed to be used on that day. Does Jotin Diori speak about this car? He has not spoken anything in his confession that a car of Muhi Hendik had been gone. In fact, he has not even named Muhi Hendik in his confession. If your lordship comes to page 667, volume 3. IO has not brought any evidence that between 5th and 15th, there had been other instances there or there could have been, which is not even a criminal trials standard of proof, but somebody may have gone. It is the only one date, 5/8/2004, when certain persons were shown the field. So assuming that is the day when the bomb was planted, where is the car on that day? Was it used? Jotin Diori does not say about it. None of the witnesses say about it. IO himself does not say. He just said it has been used in the incident. When was it used? And Jotin Diori, above all, does not name Muhi Hendik. Now, the beauty of the trial judge's judgment comes at 498.
Uh, You're saying the time period between 5/8 and 15/8 not explained.
There's nothing, nothing on it.
What did you want to say by that?
My submission is, my lord, the IO in his evidence has stated this car that was seized from my wife was used in the incident. So if that car is used in an incident, there can be two instances. The bomb was taken in this car and planted, or this car was used to recce around the place of occurrence, or after planting the bomb, these persons ran away in this car. These can be the only circumstances. Who has come forward and said that this car was present at the place of occurrence or was used? It is the IO. I understand. Nobody is going to come and say, as your lordship said, it will all happen in the dead of the night. I understand that. When you have seized the car, if you are so sure that this was used for the commission of offense, have you sent it for FSL to ascertain if at all bomb was carried? Because there could have been traces of RDX and PTN. It may not have come out, a negative result may have come out, but has it been sent? No. Then on what basis he is saying that this is used in the offense? Anybody, any stray person out of the 55 witnesses, any stray person who comes and says that we have seen this registration car going around the place, nobody. And I am being arrested on because of three incidents, three reasons. My phone call with Dipanjali, no 65B certificate to that, no contents of the phone. What we talk, how much we talk, how long we talk, nothing. Secondly, my car seized from my wife, and third, a pocket diary, which was seized from me, which was exhibited before the court. The seizure list was exhibited, but the IO says, I do not know the contents of the pocket diary. So why have you seized it? For what for have you seized it? None of the witnesses has even named, even except the IO in this fairy tale has said, nobody has named me. So why have you pulled me? Mr. ABC can be an alpha. There's no harm about it. If he calls me, if I have known him, if he calls me, I pick up his phone. Does it mean I'm alpha? Can I be booked under 10 and 13? In that context, if that be, assuming these people are alpha, his wife calls me, what is the state of my husband's case? Does it mean I am alpha?
Anything else?
That is my humble submission. Jotin Dwari has not named me in his confession statement. I have just been brought on whims and caprices of the highway. I'm obliged.
Yes, what is?
My lord, regarding
You are
66
convicted under what section?
My lord, I was on bail, my lord.
And that is not the question. What is the question that I put to you?
My lord.
Give us the file.
Request is under section 10A 4 of UAP Act.
10 of the, give us the.
10A 4 of UAP Act. 4 is one.
UAPA. Unlawful.
Accused. And 13(2) of UAP Act.
Is your case arising out of the same impugned judgment and order?
Out of my 58 witnesses, no, no, my name, only my wife and my sister-in-law, in her statement, stated, 4 or 5 boys came to my house, before the occurrence of incident. And only the conviction on the basis of that incriminating materials recovered from my house, That is the only sentence used in the entire judgment. Incriminating materials. That incriminating materials, one gamusa,
Just
and
a
one
minute,
toothpaste.
just a minute. You have been charged also on the explosive substance? No,
No,
13-2.
32 we have been. And 10A for
Yes, so what is your case?
my senior had read entire my evidence of the case. In the
No, has not read it.
the conviction against me, the allegation against me, only allegation against me is that incriminating materials recovered from my house. That is the only allegation.
Where does where is the finding of the
There is a
learned
finding
trial
of
court?
this matter.
Page?
488,
418,
488,
1880,
888.
Huh?
488.
488. Okay. Para?
Last line, recovers of incriminating materials,
Yes.
from the house of Haman Gubin. That is a allegation. That is the only evidence against me. But kindly explain, madam.
But what are the incriminating materials?
491.
Huh?
491. 490, madam. Kindly 115.
490 or 91?
Both matter.
Huh?
Both matter. Both are recorded. Madam. First matter 490, 491, madam. 115.
Go see, you see.
Sale, madam.
Go in
491?
sequence, don't go as you wish,
Oh, sorry, madam.
You go to the head, then to the tail, then to the stomach. You go in sequence.
Madam, 491, madam.
490, which para?
115. PW 30, madam. There is a
490?
491, madam.
Then you wanted 490 also.
No, 490, 491.
You said it has to be both,
490,
only 490, 491.
491.
Para.
Paragraph 105.
Yes.
PW 30, this is our
Huh.
investigation officer, madam. He stated that few days prior to the incident, and about 4-5 boys came to the house and wanted to have food at her house and threatened them with dire consequences if they failed to provide the food. That's the wife of the madam present. She stated that at that time, her husband was away from home police seized a bag from a house where a gamusa and Colgate was found.
Who is PW 30?
This is the wife of the appellant.
Wife of
The appellant.
appellant,
One
Hemen
gamusa-
Gogoi.
Hemen Gogoi, wife of the Hemen Gogoi.
So this is the reason why you were,
Mad. This is the only reason. So one incriminating method is a what method, one gamusa and one this method. That's why method I was granted bail method. In the IML discussion was. Except that method, nothing has been recorded method.
okay, madam,
Tomorrow. Tomorrow I'll let you back. I'll also call out the circumstances.
what about the citations? You are giving any citations?
We're passing it on if your lordship.
My God,
Make
so sick.
small ones. I'll summarize them tomorrow. Small
You,
ones.
Doesn't seem to-
how many, wait, how many citations are you giving?
My lord, 9
9.
on various points.
Have you give a small list
I've
before
given,
that?
With an index.
With an index, because this,
With page facing it.
topic wise it's there.
You'll give us 9, he'll give another 5, you'll give another 2, she'll give another 6. At the end, we are stuck with around 30 judgments. And you see, I can understand you giving judgments, but then please do not, repeat the same thing over and over again, because they're, the Supreme Court and other high courts, they cite, they lay down the law, no doubt. But don't give, the law 2-3 judgments on the same point.
No, one judgment in every point. It deals the entire, against the entire impugned judgment.
So we can continue this after lunch at 2. And
I'll do it tomorrow if they
he's
want
doing
to
it
place the
tomorrow, but you
judgments.
complete your thing after lunch. Okay. Yes, yes, done.
Your lordship sees the order is at page 8. The relevant portion is at page 9. Accordingly, considering the health condition of the applicant, we grant interim bail of 2 months with effect from the date of release of the applicant from the Morigao District Jail. It is directed that the applicant shall surrender before the concerned jail authorities immediately on expiry of 2 months.
Okay.
Now, the issue is, it is not, he was convicted by the session judge. Session judge is saying to whose satisfaction the bail bond, if at all.
Correct.
So if his, the only
And
clarification
the
is,
amount of surety.
he can be gone, released on PR bond. 389 says so, it's an interim bail. In fact, 389 has that provision for PR bond, personal bond. It's a
Yes,
two
that can
months.
be done. PR bond 389.
And so health grounds.
But who is he?
He is Brodeshwar Bordla, he's been convicted for 302, along with 2 of his sons.
Pay some amount. What is that?
Ah.
They don't, you're not paying it anyway.
Well, look
Okay,
at
I'll leave
one
it to your lordship.
surety.
I'll leave it to you.
Right. Heard, Mr.
DK Bhattacharya.
D.K. Bhattacharya, learned counsel for the applicant who submits. That clarification and modification of the order dated 2/6/2023 passed in IA criminal 421/2023 may be made, in as much as this court had not specified the amount of bail bond for grant of bail, and whether the surety was to be to the satisfaction of the
Learned Session Judge Morigao.
learned session judge Moreva.
Only one thing is subject to correction, of course. It's a bail order and it amounted to clarification. So perhaps same bench or
Because that bench is no longer there, my lord.
because Mr. Justice.
It is no longer there.
It
It
is
is a
not
held
there.
ground.
It's a, you see, when it's a slight, I mean, because now it's the court basically.
Yes, yes.
It is not a review or anything, it's nothing. It's court, it's the court. It's not Mr. X or Y. Pustak.
It's a court.
Miss S. Jahan, learned additional PP, SM. Submits that she has got no objection to the application being allowed. Pustak. On considering the order dated 2/6/2023 passed in IA number, IA criminal number 421/2023, comma. We clarify the above order and state that the interim bail. No, we state that and clarify that the petitioner shall be allowed to go on interim bail for 2 months on a bail bond of rupees
Not a
30,000 or
30,000,
poor man, my lord. Poor man.
okay, 20,000, 20,000. With one surety of the like amount, comma, to the satisfaction of the learned
Session judge.
Sessions Judge
Morigaon.
Morigaon. The applicant shall surrender before the concerned jail authorities immediately on expiry of the above period of 2 months,
From the date of his release.
comma, to be counted from the date of his release. The I is accordingly disposed of.
All right.
Yes, so you are referring to some judgments,
Yeah, my lord, I have given a compile, sir.
yes?
Take your lordships to the point wise. If your
Ah,
lordship wants me
yeah.
to read the judgments, part of that. My lord, first one is standard of proof in a criminal trial.
Yeah,
That is 1976 4 SCC, page 233.
yes,
The relevant portion is at page 6 of the compilation, my lord.
para 6 and 7,
Para 6 and 7, relevant in the compilation is page 6.
okay, page 6.
If your lordship comes to page 6. After the quotation, there's a line, the courts below appear to have convicted the appellant. The lordship has it. I have tick marked it. From
Yes,
where it starts. The courts below appear to have convicted the appellant on the basis of the decision referred to above and have held that since the explanation given by appellant was false, an inference of misappropriation could reasonably be drawn against him. This proposition cannot be doubted, but the question is whether the explanation given by appellant in this case can be said to be absolutely false. Another question that arises is what are the standards to be employed in order to judge the truth or falsity of the version given by the defense? Should the accused prove his case with the same amount of rigor and certainty as the prosecution is required to prove a criminal charge? Or is it sufficient if the accused puts forward a probable or reasonable explanation which is sufficient to throw doubt on the prosecution case? In our opinion, 3 cardinal principles of criminal jurisprudence are well settled, namely, the onus lies affirmatively on the prosecution to prove his case beyond reasonable doubt, and it cannot derive any benefit from weakness or falsity of the defense version while proving its case. Number 2, that in a criminal trial, the accused must be presumed to be innocent unless he is proved to be guilty. And 3, the onus of the prosecution never shifts. Now, the first proposition has, in our case, the prosecution been able to prove it beyond reasonable doubt. There are lapses there. They have not been able to, and they cannot derive any benefit that we have not done this, we have not proved our case, or we have not given a probable explanation. Paragraph 7, my lord. While the courts below have enunciated the law correctly, they seem to have applied it wrongly by overlooking the mode and nature of proof that is required of the appellant. A perusal of the oral and documentary evidence led by the parties goes to show that the courts not only sought the strictest possible proof from the appellant regarding explanation given by him, but went to the extent of misplacing the onus on the accused to prove even the prosecution case by rejecting the admissions made by the prosecution witnesses and by not relying on documents which were in power and possession of the prosecution itself, on speculative presumptions that they were brought into existence by the accused through the aid of officers. Furthermore, the courts below have failed to consider that once the appellant gives a reasonable and probable explanation, it is for the prosecution to prove affirmatively that the explanation is absolutely false. In a criminal trial, it is not at all obligatory on the accused to produce evidence in support of his defense. And for the purpose of proving his version, he can rely on the admissions made by the prosecution witnesses or on the documents filed by the prosecution. In these circumstances, court has to probe and consider the materials relied upon by the defense instead of raising an adverse inference against the accused for not producing evidence in support of his defense. Because we have already stated, prosecution cannot derive any benefit from the support of the weakness of the defense case. Prosecution has to stand on its own legs and it has to prove the case beyond reasonable doubt. Now, involvement of any of the accused on the touchstone of these principles, where have they come up with any concrete evidence that these and only these accused are the masterminds of the crime? There's nothing. It's just the IO who has cocked up a story and he has said, I have found this. From where have you found? Number two, my lord, video recordings done before the investigating officer are inadmissible as evidence. That is 2022 SCC Online, Supreme Court 1449. Relevant part is at page 29 of the compilation. Why I'm relying this, my lord, this house search of Dipanjali was done. It was recorded. Some witnesses come and said that it was recorded. While search was done, video recording was done. All those cassettes were seized. The video cassettes were seized. Those cassettes were not made part as.
But how does it matter?
It does not matter. Just for your lordship's convenience, I'm putting it.
No,
If your
no,
lordship-
it
if your
has-
lordship
it
rejects
has
it, I'm
got-
not-
it has got- You're just wasting the pages
I'm
and
not-
the time
I'll
of
not-
everybody.
I'll not trouble then your lordship with
No.
this. I'll not trouble your lordship with this. Number three, my lord. An admission of an incriminating fact, howsoever grave, is not in itself a confession. Relevant page 39. This is in respect to the main ground of the prosecution that Jatin Duari has confessed to his crime. Page 39.
Yes.
To attract the prohibition enacted in Section 24 Evidence Act, these facts must be established. Number one, that the statement in question is a confession, that such confession has been made by an accused person. Number three, that it has been.
Give us the evidence act. Is it here?
If your lordship wants to see section 24 first. Section 24, confession caused by inducement, threat, or promise when irrelevant in criminal proceeding. A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, or promise, having reference to the charge against the accused person proceeding from a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable for supposing that by making it, he would gain any advantage. This is important. So for supposing that by making it, he would gain any advantage or avoid any evil of a temporal nature in reference to the proceeding against him. Now here from PW1 to PW54 are all non-official witnesses. PW55 is the first official witness, the magistrate who comes and deposes about a confession made by Jatin Duari. It was suggested to the magistrate that has he said that voluntarily he has been confessing. Magistrate in her cross-examination says, I have not asked whether this confession is voluntary or not. That is the first time that Jatin Duari puts forward his case. Trial judges said it's a belated stage. I cannot say when PW55 the magistrate is coming. It's the prosecution who has got him on at that fag end of the trial. So my stage to confront the magistrate arises when the magistrate comes, be it PW when.
But couldn't you have made a application earlier?
My lord, that is not the way criminal jurisprudence goes actually, what is my story as regards a witness, I will put before him when he's brought for cross-examination.
No, why not? Why can't you make an application at the first instance saying that this was done and not as per my wishes, but due to the coercion of the prosecution or the police?
My lord, there comes, I am disclosing my defense. I do not disclose my defense till the end of trial. One prosecution evidence ends. The
Where
state,
is the question of defense? It is a question of you correcting a wrong, perceived wrong.
no, my lord, that is my defense. That is my defense. If prosecution has done something wrong, the benefit is always on me. I should get the benefit. So that is my defense story. What are the
But then there was nothing barring you from not giving your confession.
there was nothing, not bad, there's nothing, I understand, my lord. But still, I was facing a trial. I will confront the person who has taken my confession. And what have I asked him? If your lordship goes to the cross-examination, I have not confronted anything. First thing of the cross-examination is,
No, I'm not on the question of whether your evidence touched upon any major issue or not. I am on the issue of where was the bar in you retracting your confession by way of an application at the first instance after the recording of the same had been done.
exactly, my lord. Then I fall back to the first citation I gave to your lordships.
Ah.
That I just need to prove a reasonable doubt or a reasonable understanding that this may also happen. I need not have to prove my case.
No,
And it
but then,
yes.
but then the Supreme Court also has said that convictions can be based on retracted confessions.
They have said, I have brought judgments for that. I have brought a judgment, it is there. But if it is a retracted confession, what happens? Confession is retracted. Everything else that has been said forms the story. The retracted
It has to
confession
be
is an addition-
corroborated.
Yes, retracted confession is an additional thing. The retracted, it's just additional thing. So it is just fortifying the story.
But then, you see, now, when you wait for the last instance to retract, it appears that you have got an afterthought. It's
I
a
would
bit,
then know, my lord, I would say one thing then. This confession that I have given, who exhibited it? This person, this magistrate? Suppose he does not exhibit it. Can the court look into it?
No, it was
why
it
should I-
exhibited? Was it exhibited
Yes, it is exhibited.
by the
By
magistrate?
the magistrate, it is exhibited.
Okay.
And I have brought on record, I will place judgment, mere exhibiting a document does not amount to the proof of its contents.
No, that is there, that is with,
So-
but this is,
so the question, my
that, I do not know whether section 164 confession would be applicable to that.
I understand, my
those
lord,
issues.
but that to your lordship's question that has come, or to the what the trial judge has said, it's a belated stage. Suppose this magistrate was not even brought. Suppose that he was brought, this document was not even exhibited. What is my necessity to say that this is a false document or this is a document product of inducement or
We
force?
we don't know the workings of all the lawyers.
That is
The
what is
High
my
Court,
lord.
it might be different, the District
That
Court
is
might
why,
have. been
what
different.
it is, my lord. That's why Supreme Court has changed, my lord, in 2022, they have said in the case versus Manoj versus Madhya Pradesh, I guess, it's a case of 302 and death sentence. Death sentence was set aside, one of them was acquitted. One of the things that was given is, one of the ratio that was laid down is, if police collects 100 documents in investigation, in the charge sheet, they gives a list of documents that we are going to rely on these 90 documents. But it is mandated that the other 10 documents that you are not relying, that has to be also given to the accused, so that if he wants, he can take a benefit of those documents. Now, in this case, police has given these documents in police papers, but they may not have relied upon it. They had to exhibit it. The exhibited documents has to come before the court.
So it was exhibited.
It was, yes, the moment it was exhibited, I cross-examined. The moment it was exhibited, same day, the first question that was put to the magistrate is, was it voluntary? Have you asked the accused, was it voluntary? The magistrate replies, before recording confessional statement, I did not ask the accused as to why he wanted to make confession. That itself was not there. What is the 164 confession?
So you have given a citation with regard to that here?
Retracted confession.
No, with regard to if the magistrate had not asked you that particular question,
That is
what would be the effect?
my lord, that is what reflection time in a confession is. You are brought from
No,
judicial
Mr.
custody.
Counsel, you see, reflection time is reflection time.
Yes,
That is a different issue. Reflection time can be for 50 minutes or 1 hour or 1 day or whatever. That is a different issue. What you're harping on now is that the magistrate did not ask you as to why you wanted to make the confession. Now, the question put to you is, if the magistrate had not put to you that question, what would be the consequence of not asking that question? Has in any citation been
it is not in that compilation. If your lordship wants, there are safeguards, there are citations, safeguards to be taken up
that
by
is,
magistrate.
if you are taking that point,
Not
which you
just
are
that point.
taking, you're taking it. So you please support your arguments with some citations. That's all we're saying.
Okay, my lord, the later part of the confession, the later part of the cross examination, what I am more relying upon, I will go come. My lord, it is, there I have strictly stated. I have asked the magistrate, I recorded the confession in my statement chamber. It is not a fact. I did not make the accused aware properly confession made by him shall be used against him. I did not ask the accused whether he was going to make the confession for fear of police torture or under pressure. This is my suggestion to the magistrate. Have you asked the accused that is he making the confession under fear of police or police torture? This is my first case. And that is the retracted confession. That is 2 + 2.
And what is the consequence of that?
Magistrate cannot rely on this confession statement cannot, it is under inducement or threat.
That is only a suggestion. That is only a suggestion.
My lord, if your lordship wants the decision on this exact point, I'll get it tomorrow. But if it under threat or inducement,
Mr. Counsel, when you are bringing judgment on irrelevant points, like your number 2 judgment, then bring some judgment on relevant points which you are
my lord,
repeatedly
I
harping
wouldn't say
upon.
that if his lordship is saying it's an 11 point, I understand, but these
No,
are the points
this
that
is video recording. This
trial
vid-
judge has taken all that into consideration. I am convicted for life on the basis.
because of the video recording.
Yes, everything has been on cumulative effect of all the evidence. That is the observation by the trial judge.
No, but then does the trial judge specifically mention video recording?
Yes, for other accused, my lord, see, so her house search of Dipanjali was done. That was video recorded. My allegation against me is I kept on calling Dipanjali. So if Dipanjali is a alpha cadre, trial judge is taking me to be an alpha cadre. There's nothing against me of my car. They could not do anything about my car. The car is used for the crime.
No. So what is your connection with Dipanjali?
I used to call her. There were phone contacts between her and me. Just the phone contacts. What was the content of those phones was not there. What we used to talk, any SMSs not there. So much so, on which dates I have called, that is also not on record. A blank statement that I used to call her, she used to call me. Problem is, my lord, this is not pinpointed judgment. It's a cumulative effect of all the circumstances. So I have to deal with all the circumstances, be it reasonable or unreasonable, admissible or inadmissible. That is where I am, because I'm under 302. I'm facing life sentence.
Anyway, that is one aspect of the matter. The other aspect of the matter is you are saying that since those questions were not put to you prior to you giving a statement under 164, then what is the consequences of those questions not being put to you? It should be brought to the notice of this court in respect of citations made by the apex court or this court.
I crave your leave for that. I'll put forward those citations. I'll come up with it. This page 39 that we're going through. If your lordship wants to skip this now for the time being, this point. What should
We
be a
can.
confession? What should contain a confession? Point 3. Admission of an incriminating fact.
Page 39, yes, let's go.
39, para 14. To attract the provisions enacted in section 24 Evidence Act, these facts must be established. Number 1, that the statement in question is a confession. 2, that the confession has been made by an accused person. 3, that it has been made to a person in authority. 4, that the confession has been obtained by reason of any inducement, threat, or promise proceeding from a person in authority. 5, such inducement, threat, or promise must have reference to the charge against the accused person. 6, the inducement, threat, or promise must, in the opinion of the court, be sufficient to give the accused person grounds which would appear to him reasonable for supposing that by making it, he will gain any advantage or avoid any evil in a temporal nature in reference of the proceeding against him. So I was under inducement. This is why the magistrate ought to ask. Para 15, in the present case, facts 1, 4, and 6 have not been established. Firstly, the statement in question was not a confession within the contemplation of section 24. It is now well settled that a statement in order to amount to a confession must either admit in terms of the offense or at any rate substantiate all the facts which constitute the offense. Mere admission of an incriminating fact, howsoever grave, is not by itself a confession. A statement which contains an exculpatory assertion of some fact which, if true, would negative the offense alleged cannot amount to a confession. Now, if a lordship sees that confession of Jatin Duari, what have I stated? I was put at gunpoint. I was taken to show a place, show a safe way out. That's it. He has not even stated we had taken a bomb and planted it there. Or he has not even stated we had carried something in a bag. I'm giving that much latitude to the prosecution. He has not stated anything. So whether it was the confession of the guilt or the crime they have been accused of. If we go by the prosecution story is fifth, some people goes to Jatin Duari, puts him at gunpoint, plants a bomb, and the bomb goes off on 15th. That has to be the only prosecution story. And the car is used. The car is nowhere now. Only after my arrest, my wife is called, please bring the car. And it sees and says it's been used for the crime. Our entire story, that is not a confession. My lord, next point, statement made by a witness under section 164 is not a substantive evidence. Your lordship knows this. Same can only be used to either corroborate or contradict its maker. That is point number 4, page 46. So this is our High Court judgment. Relevant pages at page 46. Para 7, down below. Learned trial judge, as has been very rightly pointed out by the learned counsel appearing for the appellant, has fallen into an error of law by confusing himself with a confessional statement of an accused recorded under section 161 CRPC with that of a statement recorded under 164 CRPC. A mere reading of para 26 of the impugned judgment would go to show how confused the approach learned trial judge is from the statement of witnesses, which is switched over to a confession statement of accused recorded by the magistrate 164. Subsection 1 of 164 itself speak of a confession or a statement of witness so recorded under section 164 as substantive evidence. It has been held by Supreme Court in a team of cases that a statement under 164 CRPC is not substantive evidence. Statement under 164 in the course of investigation is not substantive evidence. It can only be used to contradict or corroborate a witness. An admission of a witness admitting that his statement was recorded under 164 and whatever he has stated herein before the recording magistrate was true would not make the entire statement admissible, much less that any part of it could be used to substantive evidence. Now, why I'm relying on this? PW 35, Mohendra Kaur, who had stated in his confession statement that Muhi Hendik and another 3 persons met him, told him we have certain demands. We went to the minister, Bharat Nara, we laid down our demands. And during that conversation, when we met Mohendra Kaur, we said that we belong to an organization who treats good people nicely, bad people harshly. That is his 164 statement of Mohendra Kaur. When he came before the court, he says, well, I have said what the police has said, I have just repeated that. And these were taken into consideration. Point 5, my lord. This is the recent Supreme Court Evidence Act amendment. The admissibility of electronic records as evidence depends upon satisfaction of mandatory conditions as prescribed under section 65B Indian Evidence Act. That is at page, relevant portion is at page 61. Paragraph 14. I'll also take my lordship to paragraph 13. I missed it. In the statement of objects and reasons to the IT Act, that is the Information Technology Act, it is stated thus: new communication systems and digital technology have made drastic changes in the way we live. A revolution is occurring in the way of people transact business. In fact, there is a revolution in the way the evidence is produced before the court. Properly guided, it makes the system function faster and more effective. The guidance relevant to the issue before us is reflected in the statutory provisions extracted above. Para 14. any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedures prescribed in section 65B. 65B deals with the admissibility of electronic record. The purpose of this provision is to sanctify secondary evidence in electronic form generated by a computer. So my call records that had been taken, those are calls generated from a computer. It may be noted that the section starts with a non-obstante clause. Thus, notwithstanding anything contained in the Evidence Act, any information contained in an electronic record which is printed on paper, stored, recorded, or copied in an optical or magnetic media produced by a computer shall be deemed to be a document only if the conditions mentioned under subsection 2 are satisfied, without further proof of production of the original. The very admissibility of such a document, that is electronic record, which is called as computer output, depends on the satisfaction of 4 conditions of the section 65B subclause 2. Number 1, electronic record containing the information should have been produced by the computer during the period over which the same was regularly used to store or process information for the purpose of any activity regularly carried on over that period by a person having lawful control over the use of that computer. 2, information of the kind containing electronic record or of the kind from which the information is derived was regularly fed in the computer in ordinary course of activity. 3, during the material part of the said period, computer was operating properly, and even at the time the break or breaks had not affected either the record or the accuracy. The information contained in the record should be reproduction or derivation of the information fed in the computer in ordinary course of the activity. It has to be followed in the certificate of 65P. This has to come. IO has to state from where he has brought it. And the person who has taken the prints, who has issued the certificate, he has to come and say, yes, this computer was under me. I am the authorized person of BSNL who can take this out. So the squall records to me, Dipanjali, or anybody amongst us cannot be taken as inadmissible evidence. 66, paragraph 16, my lord. It is further clarified that the person need only to state in the certificate, that the same is to the best of his knowledge and belief. Most importantly, such a certificate must accompany the electronic record like computer printout, compact disc, video disc, pen drive, pertaining to which a statement is sought to be given in evidence when the same is produced in evidence. All these safeguards are taken to ensure the source and authenticity, which are 2 hallmarks pertaining to electronic records sought to be used as evidence. Electronic records being more susceptible to tampering, alteration, transportation, excise, etc. Without such safeguards, the whole trial based on proof of electronic records can lead to travesty of justice. Also, my lord, just one line in paragraph 22, page 64, just one line. Last portion. Thus, in the case of CD, VCD, chip, etc., the same shall be accompanied by a certificate in terms of 65B obtained at the time of taking the document, without which the secondary evidence pertaining to that electronic inadmissible. Now, my lord, the SIM card, they have seized the SIM card, they have seized the phone. The SIM card is a chip. Now, point 6, my lord. More serious is the offense, higher is the standard of proof, as degree of assurance is needed to bring home charges alleged. My lord, relevant is at page 78. Now, why I'm citing this, my lord? This is an offense of killing 13 people by a bomb. It is not a theft of a watch or a mobile phone. So the standard of proof has to be watertight. Para 10. A criminal trial is not a fairy tale wherein one is free to give flight to one's imagination and fantasy, which the IO has done. Crime is an event in real life and is the product of an interplay between different human emotions. In arriving at a conclusion about the guilt of the accused charged with the commission of a crime, the court has to judge the evidence by the yardstick of probabilities, its intrinsic worth, and the animus of witnesses. Every case in the final analysis would depend upon its own facts. The court must bear in mind that human nature is too willing, when faced with brutal crimes, to spin stories out of strong suspicion. Though an offense may be gruesome and revolting to human conscience, an accused can be convicted only on legal evidence and not on surmises and conjecture. The law does not permit the court to punish the accused on the basis of a moral conviction or suspicion alone. The burden of proof in a criminal trial never shifts, and it is always the burden of the prosecution to prove the case beyond reasonable doubt on the basis of acceptable evidence. In fact, it is settled principle of criminal jurisprudence, the more serious the offense, the stricter the degree of proof required, since a higher degree of assurance is required to convict the accused. The fact that the offense was committed in a very cruel and revolting manner may in itself be a reason for scrutinizing the evidence more closely, lest the shocking nature of the crime induces an instinctive reaction against dispassionate judicial scrutiny of the facts and law. Paragraph 12. Thus, the law on this point may be summarized to the effect that in a criminal trial involving serious offense of brutal nature, court should not be wary of the fact that it is a human intrinsic to react adversely to the commission of offense and make an effort to see that such an intrinsic reaction does not prejudice the accused in any way. In a case where the offense alleged to have been committed in a serious one, the prosecution must provide greater assurance to the court that its case has been proved beyond reasonable doubt. This is what happened in this entire case. Point 7, my lord. If two views are possible, the one favorable to the accused is to be adopted, and the guilt of the accused has to be judged not by the fact that a vast number of people believe him to be guilty, but whether guilt is established by evidence brought on record. The relevant part is at page 104. Para 25. Another golden thread which runs through the web of administration of justice in criminal case is that if two views are possible to the evidence adduced in the case, one pointing to the guilt of the accused.
Next.
My lord, the next point is, last one, conviction of an accused based solely on retracted confession is unsafe. This one, page 114, relevant. Paragraph 18, my lord, page 114. 17 to 20, I'll read this, my lord. Paragraph 18 is very much required. Having thus reached a finding as to the voluntary nature of a confession, the truth of the confession should then be tested by the court. The fact that the confession has been made voluntarily, free from threat and inducement, can be regarded as presumptive evidence of its truth. Still, there may be circumstances to indicate that a confession cannot be true wholly or partially, in which case it loses much of its evidentiary value. 19. In order to be assured of the truth of confession, this court is in a series of decisions has evolved the rule of prudence that court should look to corroboration from other evidence. However, there need not be corroboration in respect of each and every material particular. Broadly, there should be corroboration so that confession taken as a whole fits into the facts proved by other evidence. In substance, the court should have assurance from all angles that the retracted confession was in fact voluntary and it must have been true. The law on the subject of retracted confession has been succinctly laid down by 3 judges bench of this court in Subramania Gowda versus so-and-so, which states the next question is whether there is corroboration of the confession since it has been retracted. A confession of a crime by a person who has perpetrated it is usually the outcome of penitence and remorse, and in normal circumstances is the best evidence against the maker. The question has very often arisen whether a retracted confession may form the basis of conviction if believed to be true and voluntarily made. For the purpose of arriving at this conclusion, the court has to take into consideration not only the reasons given by making the confession or retracting it, but attending facts and circumstances surrounding the same. It may be remarked that there can be no absolute rule that a retracted confession cannot be acted upon unless the same is corroborated materially. There has to be independent corroboration from other sources. Retracted confession can only lend support to the prosecution case. It cannot be the sole basis. It cannot be the only basis of my conviction. Paragraph 20, my lord. In Pyare Lal, the same principle is regarded to the evidentiary value of retracted confession has been reiterated. A retracted confession may form the legal basis of conviction if the court is satisfied that it was true and voluntary. But it has been held that a court shall not base a conviction on such a confession without corroboration. It is not a rule of law, but is only a rule of prudence. It cannot even be laid down in an inflexible way of practice and prudence that under no circumstances such a conviction can be made without corroboration, for a court may in a particular case be convinced of the absolute truth. But it may be laid down as a general rule of practice that it is unsafe to rely upon a confession must latch on a retracted confession unless the court is satisfied that a retracted confession is true and voluntarily made and has corroborated in material particulars.
That's all.
This is my entire matter.
Yes. Yes. What is your citation?
We have common citation.
Okay, anything from your side? No. Okay, then Ms. Jahan will be
tomorrow we'll give an effort. Because I'll take help from 164 statement of few witnesses. Because 164 can be used only for corroboration and contradiction if they resile. There is no resiling here, but then I'll take some support from 164.
Whether the confession statement can be retracted during 313.
It can be retracted, but if I can show that the confession was voluntarily made, retraction will not be fatal. That Pabuni judgment I'll bring. Confession.
Of course, one major aspect that you'll have to look into is with regard to what is the evidence against the apparent.
Yes. These appellants specifically. Bomb blast.
Yes, you see, bomb blast is an admitted fact. Their death is an admitted fact. But what is the connection or the link between them
And the bomb
and the
blast.
bomb blast?
And 164, 1 or 2 witnesses have stated that they had come to plan for a bomb blast. So I'll take that cue. Otherwise,
Or they have come to plan.
that is there in 164 statement. Now I'll have to see how far it's applicable, reliable.
164 statement of which,
Uh,
I thought there was only 164 statement
No, 164 of witnesses.
witnesses. Oh,
Witnesses.
164 witnesses.
Witnesses,
Okay, the confession statement, there's only one.
Khoghen Borgohain, I'll have to see whether he said that he did it
And then
after being tutored. I have to see.
All those, all their
Organ Borgohain, the statement.
He
How
said
many?
about the bomb blast.
No, the Organ Borgohain is a appellant.
No, he is one of
witness.
the witness.
He's a witness. So he
His
made a
164 statement, because at his place, he was called by the police, talking about the occurrence, and then perhaps these are the statements which they had said in the police statement. will
Because
again-
as of now,
Huh,
as far as we are able to see, there's nothing much that is really correcting them,
hmm.
correct? So we'll have to see what new things or what did we miss something out
Hmm.
that the learned trial court saw, but we are not able to see as on.
I'll have to see,
You'll have to support the,
Learned trial court, they did not even call out the circumstances and make it a chain. It was kind of, they did in a haphazard manner. I'll have to call out the circumstances and if the chain is complete. Because a criminal case has to be decided either on ocular or on circumstance. So circumstance is the case in the instant case. So circumstance, if I can show few days before they had planned in, and with that planning, they came to the house of these two persons, Chandrakanta Gogoi and Hemen Gogoi. And then they left a bag. Of course, that bag had only a dagger and other things are not material. That pocketbook is there.
but what was the contents of the pocketbook?
He
That-
says, I do not know. I also,
That of course is, the pocketbook is perhaps not exhibited.
the Caesar list is exhibited.
Caesar list, it's there, material exhibit is not there.
IO in his evidence at page 110. He says, I have no knowledge regarding the contents of the pocket diary.
They should have materially exhibited that pocketbook. So after that, if they had come, after that Jatin Dawari's statement that
What
they had
about this
seen the.
What about this Hemen Gogoi?
Hemen
Only this Gamosha and
Hmm.
one Colgate toothpaste.
No, his house was searched, I think.
But then, yes, but then no, but
he was not
what
there.
was the incriminating evidence?
I'll
That was
place it, I'll place it tomorrow.
Anyway, you just think of all these issues.
Yes, of course.
Tomorrow will it be possible for you? Tomorrow,
If I get some time, then it would be better, like. But then Lordship should remember everything, whatever
that
has
is the
been
thing.
done now.
you call data. You can go.
Day after, otherwise,
We can try for the after.
there are hearing matters tomorrow from number one itself. Then lordship, day after tomorrow or?
Wait, we'll just dictate a little bit.
Yes, the
of what-
facts.
Yes, the facts at least. Otherwise, we'll have a problem later. Okay. In this 15, 16, 17, that order we passed in item 70, that has to be cancelled. 15, 16, 17. Heard Mr. A.K. Das. Yes. Learned counsel for the appellant in criminal appeal number 311/2019. Also heard Mr. D.K. Bhattacharya, learned counsel for the appellant in criminal appeal 305/2019. And Mr. A. Khanikar, learned counsel for the appellant in criminal appeal number 365/2019. The appellants have filed the above three appeals under section 374(2) CRPC against the judgment and order dated 4/7/2019 passed by the learned Sessions Judge, Dhimaji in Sessions case number 127(DH) capital, bracket close, of 2011 arising out of Dhimaji PS case number 202/2004. Full stop. The appellants in criminal appeal 311/2019 and 305/2019 have been convicted and sentenced under section 302/120 bracket B /323 IPC, read with section 3 bracket A,
Small.
small a, and 4 bracket small b bracket 1 of the Explosive Substances Act, read with what about
10.
read with section 10
10,
bracket B bracket I and 13 bracket 1 bracket A of the Unlawful Activities bracket Prevention bracket close Act
1967.
1967. Pusta. The appellant in criminal appeal slash 365, appeal number 365 slash 2019 has been convicted and sentenced under sections 10 bracket B bracket I. Is it?
10 bracket,
No, 10 bracket, 10
4.
bracket A, 10 bracket
Bracket
A
4.
bracket Roman 4, small, huh? And 13 bracket 2 of the unlawful activities bracket Prevention Act, comma 1967, hereinafter referred to as the 1967 Act. Huh? Pusta. The appellants have been convicted on the above charges in relation to a bomb blast which occurred at 8:55 AM on 15/8/2004 in the Demaji College playground, comma, where Independence Day celebrations were going on. The effect of the bomb blast killed 13 persons on the spot, while grievously injuring 19 to 20 persons. It is the case of the state respondents that the United Liberation Front of Assam, bracket Alpha in short, comma, a militant outfit banned by the government of India, had exploded the bomb in order to create an atmosphere of terror with an aim to create an independent nation, comma, by declaring war against the state. Next paragraph. The prosecution case in brief is that an FIR dated 15/8/2004 was submitted by SI Ahmed Ali, comma, Demaji Police Station, to the officer in charge, comma, Demaji Sadar Police Station on 15/8/2004 with regard to praying that an investigation should be conducted due to the bomb blast that occurred on 15/8/2004 in the Demaji College playground, killing 13 persons and grievously injuring 19/20 persons. In pursuance to the FIR dated 15/8/2004, Demaji PS case number 202/2004 under section 120B/121/121 bracket A/122/302/326 IPC, read with sections 3/4 of the Explosive Substances Act 1884 and section 10/13 of the 1967 Act was registered. during investigations conducted by the IO. Where is the charge sheet?
It is not in my paper book. 14 persons were named.
Huh?
14 persons were total named.
Were killed
Named as accused, 14 persons.
during investigations, 14 persons were named as an accused, which included all the 6 appellants herein. Gustav, where is the charge sheet? Which page?
Charge sheet is not there, charge is there. Charge is at page 6. Charge order. Charge is there,
Page 692.
692. Volume 3, my lord.
Fifteen persons, I think, not 14.
No, my charge was against 14%. 50.
What have I said during investigations? I am not hearing you.
During investigation, 14 persons.
During investigations, the IO found sufficient grounds to prosecute 15 persons. And the charges stated in the foregoing paragraph. And accordingly, I requested the district magistrate Dimaji to grant prosecution sanction to prosecute the 15 accused persons. Gustav. After prosecution sanction was granted, correct? You just correct me in the facts. Charge sheet was filed on
28/2/2011.
28/2/2011. 28.
2 years.
28/2/2000. Next paragraph. Where is the framing of charge?
Page 6, volume 1.
Next para. Charge under section 120(b), 302, 326, 323, section 3 and 4 of the Explosive Substances Act 1884. And section 10 and 13 of the 1967 Act were framed against Jatin Dowry, alias Rangman, alias Mrityunjoy Gohain. That is at page 6, okay. Comma. Leela Gogoi, alias Leela Khan. You make it 1-2, huh? One is Jatin Dori, number 2 is Leela Gogoi. Number 3 will be Srimati Dipanjali Gohain, alias Lipi, Lipi. And number 4, Muhi Handik, Muhi, Handik. Acha, this way you write. 1, 2, 3. After 1, 2, 3's name, you just put bracket. Appellants in criminal appeal number 3/11/2019. And Muhi Handik, number 4, and Muhi Handik, bracket. Appellant in criminal appeal number 305/2019. Acha, and Hemen Gogoi. Wait. No. Sorry, wait. And Hemen Gogoi. And Hemen Gogoi, bracket, appellant in criminal appeal 365/2019. Next para. During the trial, "58 prosecution witnesses and 2 defense witnesses were examined by the learned trial court." After the deposition of the witnesses and statements of the appellants were recorded under section 313 CRPC. The learned trial court passed the impugned judgment and order dated 14/10/2020. No. Wait, not that.
4/7.
Passed the impugned judgment and order dated
4/7/2019.
Where is that?
Hello, the judgment is at volume 2
Volume 2.
and it starts at page 441. The lordship comes to 442, the date is there.
The impugned judgment, pass the impugned judgment, only judgment, pass the impugned judgment dated 4/7/2019 in Sessions case number 127 bracket DH capital /2011. Gustav. By the said judgment, by the said impugned judgment, The learned trial court. Convicted. The appellants, the four appellants in criminal appeal number 311/2019 and 305/2019 under section 302, 120B, 323. No, 302, 302, read with section 120, read with section 120B IPC, say 323, read with section 120B IPC, section 3A, capital small, A, not capital 3 bracket small a, and 4 bracket B bracket I of the Explosive Substances Act, read with section 120 IPC, and section 10 bracket B bracket I and 13 bracket 1 bracket A of the 1967 Act. This is at page 500. They were accordingly convicted. They were accordingly sentenced to undergo rigorous imprisonment for life and to each pay a fine of rupees 10,000, in default, RI for 2 months under section 302 IPC. They were also sentenced to RI for life and to pay a fine of rupees 10,000 each, in default, RI for another 2 months under section 120B IPC. They were also sentenced under section 323 IPC to undergo RI for 1 year and rigorous imprisonment for life with a fine of rupees 10,000 in default, RI for 2 months under section 10 bracket B bracket 1 I small of the 1967 Act. They were also sentenced to RI for 5 years each and to pay a fine of rupees 2,000 each, in default, RI for 1 month under section 13 bracket 1 bracket A of the UA of the 1967 Act. My God. They were also sentenced to RI for 10 years each and to pay a fine of rupees 2,000 each in default, RI for 1 month each under section 3 bracket A of the Explosive Substances Act, and RI for 10 years each and to pay a fine of rupees 2,000 each in default, RI for 1 month under section 4 bracket B bracket small I of the Explosive Substances Act, 1884. Next para. The appellant in criminal appeal number 365/2019, that is Shri Hemen Gogoi, was convicted under section 10 bracket small a bracket Roman 4 small of the 1967 Act. And under section 13 bracket 2 of the 1967 Act. He was accordingly sentenced to RI for 2 years with a fine of rupees 5,000, in default RI for 2 months under section 10 bracket A bracket Roman 4 small of the 1967 Act. And to undergo RI for 4 years with a fine of rupees 5,000, in default RI for 2 months under section 13 bracket 2 of the 1967 Act. Next paragraph. Being aggrieved by the impugned judgment the appellants have filed the 3 appeals. The counsels for the appellant submit that except for the deposition of the of PW number 55 and 56, who is the 55, 56, the evidence of the other witnesses do not have any relevance with regard to the question whether the petitioner, whether the appellants are guilty of having masterminded the bomb blast that took away the lives of 13 persons and injured 19 to 20 persons. They submit that the entire basis for convicting the appellants is on the confessional statement of Sri Jatin Dwari, Jatin Dwari, Dowari, Dwari. Appellant number 3. Appellant number 3 in criminal appeal number 311/2019. Wherein he has made an exculpatory statement exculpatory confessional statement. Huh? He has made a confessional statement. What?
Exculpatory statement. Exculpatory statement.
He has made an exculpatory statement under section 164 CRPC to the magistrate. to the effect that alpha cadres, namely Leela Khan, alias Leela Gogoi, Pintu Bora, Prafula Bhuyan, Rashid Barali, and Niog came to his house and took him out by threatening him at gunpoint. They took him to the college gate through the front of the girls' hostel and asked him to show the college field. He showed the college field, and thereafter the said persons sent him to Tiniali. After waiting for them, which on their instructions come up, he was told to escort them through a safe passage and through a safe route, which he did. The next para, the counsel for the appellant submit that the said statement made by Jatin Dwari was retracted by the said appellant during his examination under section 313 CRPC. And as such, the learned trial court could have only acted on the basis of the statement if there was some other corroborative evidence. There being no other corroborative evidence to link the appellants or Jatin, to link Jatin Dwari or the appellants with a bomb blast, the learned trial court heard in convicting the appellants. Next para. The learned counsel for the appellants submit that a bare perusal of the impugned judgment of the learned trial court goes to show that the finding of guilt made by the learned trial court against the appellants was based, where is the judgment? Volume 3. Volume 2. Volume 2. Page. Page.
493, reasoning is at 493. Paragraph 118, page 493. Reasoning starts from there.
Was based on the statement of the witnesses under section 164 CRPC, as well as the confessional statement of the appellant Jatin Dwari under section 164 CRPC. The learned trial court also held that the appellant had recreated the scene of the crime during police investigation. which showed that the appellant Jatin Dawari was a party to the conspiracy to commit the bomb blast. What else? Besides this, there was something else.
Your lordship comes to page 493, paragraph 118.
Yes,
My lord, paragraph of 1, 2, 3, fourth line from top.
yes.
He states from cumulative evaluation of all the evidence and materials on record, it transpires alpha militants planted a bomb attack at
First of further, from the cumulative evaluation of the evidence and materials on record, it transpired that Alpha militants planned the bomb attack at Dimaji College Field and engaged its active members for carrying out the operation. What's up? Further, page 120, para 123 at page 495, huh? From here. Further, it is found that, para till the end, okay? I think my back is hurting me. So we'll just say, we just put the names, heard, so. And then, Ms. Jalan, Ms. S. Jahan. Another additional PPSN. Submits that, please that she may be allowed to give a submission,
Tomorrow, day after.
day after tomorrow. This is the matter of Wednesday. Tomorrow, already cases would have been fixed. Sir.
Yes, there are so many. Is tired of that.
Huh?
Lordship should take care. Lordship is tired
Yeah, actually the back is starting, is acting up again.
of that.